Hey, welcome back, welcome back, welcome back. Appreciate y'all being patient. I tried to fix these settings the best way I could. Day number 4, Melly in the celly. That sounds like a wrestling event. Mel in the cell. Number 8, WWE presents. That's not funny. Hopefully he'll be up out the cell. Let's get into this shit, man. Shout out to everybody in the chat. Please smash that like button. Top of the top, good morning. Shout out to all my good peoples. You did.
And this is the business records certification as included on the file from Snapchat.
Yeah, I saw those. I'm not talking about that. I'm talking about the actual videos.
So do you want to see the images larger as well, Your Honor?
Yeah, I'd like to know what you're going to show to the jury.
Of
They're
course.
objecting to it, saying it's not relevant. I don't believe there's an objection that's not authentic, that it's not his account from Snapchat. I don't understand that. If that's the case, but my understanding is they're saying it's not relevant.
This is the one that I indicated would potentially have the items the defense didn't want in, such as the names of the songs of the defendant.
We don't have to concern ourselves about that. The state agreed to get that out. So,
Image of the defendant, an image of the defendant and Mariah Hamilton, image of the defendant.
Now, you're saying that this is the defendant and Mariah Hamilton, and I haven't heard anybody identify her yet. Is that,
Correct, that's why the next witness would do that.
Oh, okay, so the witness is going to do that.
Yes, Your Honor. There she is again. That is Ms. Hamilton. This is the Snapchat logo of the defendant. Moving on to the videos.
Is it better, chat? Let me know.
This video here is before the homicide. It includes the defendant and one of the victims, Christopher Thomas. There is volume to it. I don't know if the TV is turned down.
Gary, can you check on that?
that's good.
It's up. That's 63 or 62. There is a volume.
Hey, man, welcome back, welcome back. Please smash that motherfucking like, man. Day 4, Ynw Melly trial. Y'all let me know if the screen is running better. I tried to set this shit up last night, got tired, couldn't figure it out. I got up early. So hopefully the screen runs better. I had to tweak all the settings and shit, upgrade, download the upgrade. But yeah, man, we in this thing, man. Shout out the whole chat, man. Snow gang or no gang, we here, baby. Shout out to everybody working. Shout out to everybody at school. Shout out to everybody just chilling on the couch. Shout out to everybody just laying down. You feel me? Shout out to everybody rolling up. I ain't got nothing to roll up in, but I got a bunch of roaches and clips. I'm gonna have to smoke that until lunch break, I guess. If you want to donate to the channel, I pinned the Cash App in the chat. Whatever you can send, you feel me? You know we ain't complaining. We just trying to maintain it. You did. If not, smash that like. You did.
Try VLC.
That was VLC, so.
Oh.
Sharon, I'll switch over to a different computer.
Yeah. What up, Roro? What you doing, my dog? I had to fix the goddamn settings on this bitch so the screen could run smooth. I don't know how that shit is not even. I don't want to say speak to someone. That shit ain't even lagging for real. So I guess it's. I'm looking at the playback. I guess it's good, man. Shout out to everybody in the chat though, man. Y'all smash that like we back at it like a crack addict. You did. Top of the top. He said, yeah, what up, Jason? He said, don't jinx it. Young in 321, what's good, bro? They trying to get these, oh, is that all? They ain't gonna show the videos no more? I thought they was trying to fix the sound on the video. The evidence that they showing. Slime News, what's up? Okay, yeah, they about to play it now. Fuck, I didn't even pick up my water. Why they play that? They trying. That's crazy. Wow. What the fuck is that even proving?
This bitch look like he got 5 kids at the student pickup right now, waiting.
Yarn, for the interest of time, should the state be proffering the relevance of each video as we go?
No, thank you. I'd just like to see it and see what
Right.
my understanding. Well, go ahead.
Okay.
Right. All that extra shit, man. They need the most important shit is the most important shit is like, get right there like that. You know you come back. You be someone pick up on me. Hey man, I'm 19, I done seen 750 down each. I ordered it. It'll be a meal.
I'm trying to understand what the fuck is he proving with these.
People saying we get out. People saying we get off y'all ass, man. Get off y'all ass, man. Hey, bro, don't be speaking on him, bro. He didn't do that. He didn't do that. I've been out here about your ass saying you did it.
Yeah, Melly definitely got a chance. Youngin. What up, Aldine? Yeah, he got a chance.
Videos, Counsel?
Yes, sir.
All right. So, Counsel, why don't you tell me your complete objection so I fully understand what you're objecting to on the
Right.
videos as well as the remaining portion of this Snapchat under, I think it's triple A.
Your Honor, our first objection would be relevance. I think Florida statute 9401 defines relevance as evidence tending to prove or disprove a material fact. There was not a single video that you witnessed there that implicates in any way any fact and issue in this case.
Right. That's what I said.
I want the court to be aware of what a Snapchat account is versus a video off of a phone. They're two different things. You can access.
You said what's the percentage of him leaving without any time? That's too technical, bro. I mean, well, the percentage is because he gotta. Yeah, he's only gonna be guilty or not guilty. It's not like he has other charges that could get dropped down to, you know, either he did it or he didn't, and they have to, you know what I mean. Percentage wise, it's kind of hard to say percentage wise, but he definitely has a chance. I want to say 50-50. He has a 50-50 chance. But then if you look deep into the evidence and shit, you know, it hit different.
As that Snapchat account from your computer that's right before you. So a Snapchat account or any social media account is not particular to a device. This is contents from an account that exists in the cloud or on the platform of Snapchat and is not peculiar to a particular device. So it doesn't identify a device. It identifies a social media account. The notion that anything a defendant says can and will be used against him is an issue of hearsay. It's not a relevancy issue. None of those videos I haven't heard, and I think that probably we're putting cart before the horse by making me object to the relevance before she advances her theory of relevance. But the fact is, unless I'm missing something, there is nothing there that concerns the events of October the 26th, 2018 in any way. As far as the messages are concerned, it's similar.
Now we're talking about what's in writing, correct?
What's in writing is essentially a dump from that account, a selective dump, I think from August the 3rd through some date in November. If the state is indicating that there are messages there that relate to the offense, then the state should isolate those messages and make its argument as to what the relevance of those statements is. But to suggest that you can just dump all statements that somebody makes since birth until the time of their trial, and because it's non-hearsay because it's a statement of the defendant. And by the way, these are exchanges, so a relevancy objection, or sorry, a hearsay objection relates to the statements of the defendant, not the ones that are made back to him in any kind of conversational exchange. Those statements themselves are hearsay because they aren't statements of the defendant. And now, and I'm making this argument assuming, because I'm dealing with relevancy, assuming that those statements are indeed statements of the defendant, which I'm not conceding. They have to have some relevance to this trial and facts in issue at this trial. There are some statements that I observed that seem to be some maybe terse or conversations between him and any person that might cast him in a poor light because of the manner in which he communicates. How is that relevant to this case? So relevance is number one. A statement has to be relevant. So each statement the state would have to establish the relevance of each statement in isolation prior to it being admitted into evidence. Saying these are all from his phone and therefore they're all his statements and this is a business record exception and therefore they get in doesn't cut it. As far as authenticity is concerned, and that's our relevance objection, relevance must be established. I'll cite the court authenticity issues or authentication issues concern Rule Florida Statute 90.901. And I'll cite the court to some case law that doesn't necessarily deal with social media, it deals with text messages and emails. Simonet. I can't remember if it's Simonet v. State or State versus State.
Hey, top of the top. Y'all, I just want to say welcome back, man. My bad for being late. I had to get my screen settings good, bro. That I don't know why them shits, you know what I mean, fucked up. Shout out to my nigga Music 101. Y'all go subscribe right now, man. Shout out Music 101, man. I was in your chat last night too, bro. I was just I was on my computer, so I wasn't able to say nothing, but yeah, I was tapped in last night, man, with you, bro. Shout out to everybody in the chat. I had to get my screen right. God damn it. Shit. Day number 4, man. Day number 4. Yasmin, top of the top, love. Shout out to the queens, all Dean this hoe. Mike Larry. My nigga Mike Larry. Cavelli, what's good with y'all, man? Shout out to the whole chat. Please smash that like if you ain't smash it. If you did smash it, I appreciate you 10 times over. Snow gang or no gang. Let's get back into it, man. I see Dean said he got a 40%. 40% chances. I'll go with that.
But it's 100 Southern 3rd 180, which stands for
I ain't got no blunts, y'all.
Text on a cell phone. And it indicates, these were some notes that I took down because I didn't realize she was going to be trying to bring this in today. We had asked for some indication as to the witnesses, and I think this is the only day we didn't get any indication, and so there's an element of ambush. But nonetheless, in the Simonet case, it stands for some legal principles that were articulated in that holding that I took note of. One, in that case, there was concern regarding the admission of screenshots of text messages, communications. And the court said it was okay because there was a witness that testified that she was sitting next to the defendant in a car when the texts were made. And the detective recovered a cell phone from the defendant, and the witness identified the text messages between her and the defendant. In other words, There was a party to the communication who was able to authenticate the communication and who the participants are. Another case is Roy, which is 279 Southern 3rd 238.
279 what?
Hey, yo, y'all let me know, because I, you know what, I never did it before, but did they take away my ability to do a poll when they demonetized me this last time? Like, if you demonetize, can you do a poll, or how do I do a poll? I be seeing people do that shit, but or do I gotta be? See, them motherfuckers be hating on the nigga, bro. They demonetize a nigga for no motherfucking reason. I want to do a goddamn poll. Yeah, Sukiana crazy. I wanted to make a video on that, but I don't want them to say, because what they're accusing dude of, I don't want them to be like, I'm promoting that, because YouTube is weird, bro. But that is crazy, bro.
Southern 3rd 238, which concerns emails and texts. And these were emails that were admitted through the investigator that was posing as a 14-year-old in what appears to be a case that concerns some sort of a pedophile sting. And the investigator involved in the exchange, the investigator was involved in the exchange and the emails of the text. One of the quotes that I took from that case says, most common way to identify social media, which would be this, and things akin to social media, is to let the author testify that they're the ones who generated or created it. So there's somebody that is involved in the exchange of the communication that can attest to the fact that they created it or were involved in it and identify the parties that were involved in the exchange. When a participant is used to authenticate electronic exchange, the focus is on the witness's ability to identify the person against whom the communication is offered. In criminal cases, the person communicating with the target of the investigation must be able to identify the target through some personal knowledge or experience.
I'm gonna tell y'all what the fuck they did right there, bro. The prosecutor is for me. It's easy to peep, even though, because remember I kept saying, why are they showing this nigga Snapchat show? Like the shit. Well, the shit that they was showing wasn't like, how was that relevant to, you feel me? So I think what they did, they just wanted to they wanted to show the jury like some kind of portion of him in regular life, because you know they're not using his rap lyrics. So what's a good way they could do that? Just show some fucking pictures of him with money and talking about, listen to some songs, talking about, what was that song he listened to? I'm gonna kill you and all, like making him, they think they slick. They know it don't, and they don't care if it do get objected to. But they got to show the jury real quick, look how this nigga be when he be on the street. You feel me? They think they slick though. That's kind of like them using his music. They're using his personality outside of this case. You feel me? And then they faking like it has some relevance to, when all them clips ain't show shit. That's just his Snapchat stories. It won't even nothing crazy on there. Like,
so this establishes that there has to be somebody who participated in the communication, who authenticates the participants in the exchange, and must be able to identify the participants in the exchange. In the Roy case, the sergeant, who was posing as a 14-year-old, acknowledged that he had no idea who was on the other side of the emails and texts. Here we have nobody at all, let alone somebody whose knowledge is insufficient.
This is just a PC affirm case. These opinions are, right? Am I reading this right? This is a PC affirm. That's in the concurring opinions, or?
I don't know where this case. I can print it out if you
I'm reading it right now.
I'm not sure that what the court is.
It's a PCA affirm.
Meaning the language that I'm reading doesn't exist?
It exists. I'm sure it's there. I didn't read the whole concurrence. It's
okay,
there, but it's a PCA affirm.
Well, maybe I cited it incorrectly. I have.
No, you cited it right. 279 Southern 3rd 238. All right, go ahead.
Okay, this is language I took from the cases themselves.
I don't doubt it.
Okay.
Seems like it's all here.
Okay. I'm not sure the significance of a PCA affirm meaning.
That's not the opinion of the court. It's the opinion of one judge. That's what his concurrence was. His or her opinion, and there's another judge has a different concurring opinion. The opinion, there's no specific majority opinion. I don't see one. The other concurring opinion says he reversed, but it's a PCA affirm.
I'm not quite sure of the significance of that, but I'm sure the court has a message that's communicated. No evidence that the texts were recovered from a phone, A, belonging to, in the possession
Prayers
of
up for DT, man.
the appellant
Prayers up.
pursuant to a search warrant. There's another quote. Further, in that case, the sergeant could not identify appellant as a person on the side of the emails or on the other side of the emails or texts. Lamb.
Yeah, man. Shout out to my bro DT, man. He had to go to court today. I hope we hear from him soon, man. Shout out Jason in the chat, Aldine, all the mods, all my guys. What up, Shahi, Ambrose? He said, free Melly. Sam UQ Clark said, give Melly one more chance to do the... This is not sadly, Samuel, this is not one of them cases where, you know, oh, I robbed the store or I got robbed. Like, I did something, like, people died and shit, like, in a gruesome way. This ain't one of them ones where they could just be like, well, you know what? Just let them go. Give them probation. Like, nah, my nigga. Like, nah, nigga. Like, you heard me? Nah, nigga. This ain't one of them ones, man.
Versus State, 246 Southern 2nd 400, a 4th DCA case in 2018. A quote that I took from that says, a case involving authentication of a Facebook video, or videos here, is also instructive. In that case, the 4th District recognized a distinction between authentication of a video recording and an audio recording. An audio recording would be more akin to a communication that you can't tell the identity of the communicator's visually. The 4th District acknowledged its prior holding that authentication of an audio recording, quote, should be made by the technician who operated the recording device or a person with knowledge of the conversation that was recorded. Quoting Santana versus State 191, Southern 3rd 946, which is another 4th District case. So as far as authentication is concerned, Your Honor, and the PCA affirmed component, notwithstanding the articulation that is being made repeatedly by district courts of Florida, of this state, and by the 4th District, are that when you are introducing text messages, communications that are in print, audio, somebody has to identify the participants. You can't just put them in and say, this is the guy who said it. You have to lay a predicate of authentication, which the state is not attempting to do. So as far as relevance is concerned, they have to establish relevance of each statement. They can't just say, here are all the communications he ever made, and notwithstanding who he's making them with, whose statements are themselves hearsay, because his statements are statements of the defendant and therefore not hearsay, non-hearsay by definition, they come in. They have to establish the relevance. So we object. One second.
Hey, shout out to all the people in the chat, man. What up, Slim? He said new sub. Appreciate everybody who subscribed to the channel, man. Please, please, please hit that subscribe button. And then after that, if you want to say tapped in, hit that notification bell, and you can know exactly when I'll be going live. Just like this morning, I had to get the stream a little better. And I apologize if it's still lagging a little bit. It's way better than it's been. I'm sorry. I don't know what the fuck I was doing, or you feel me? But I had to get that straight for y'all, because that shit make a nigga don't even want to scream if it got to keep freezing up every 3 seconds. I don't mind it freezing every so often or just by the internet, but so I had to do that, man. But yeah, shout out to everybody in the chat, man. Please hit that like button if you already hit it. I appreciate you. Do I think Melly gonna get off? I don't know, bro. I'm like Jason. I'm not on anybody's side. I just want to see how this shit play out. You know what I'm saying? Like, Cause I'm not gonna sit here and say like I was bumping Melly like a motherfucker. I knew a few songs. I used to hear in the clubs a couple times. That ARNM 223s. I used to hear that in the strip club. I didn't even know that was Ynw Melly. I Murder on My Mind. It was, but like a nigga like Thug or something like that. Yeah, I'm on some free Thug shit. But cause I, but I don't. At the same time, this is a crazy case. You know what I'm saying? And shit, Shanika, what you doing, babe? What you doing, babe? It's how Shanika this motherfucker. You said to do a poll. Click on the plus sign beside the ad reaction button at the bottom of the chat. Alright, hold on, let me see. Let me see something.
So
It ain't up there, bro.
Communications
Hold on,
are not particular to a phone, so it doesn't meet that hurdle. They are particular to a social media platform. A social media platform that they have to establish belongs to the defendant, and I don't think they have said how they purport to do that. Even if they do that,
What up, Jeff?
the statements of anybody else in those exchanges is hearsay. Statements of the defendant are irrelevant, and the photographs and videos are also irrelevant and prejudicial pursuant to 90.403.
Thank you, and I misspoke. There was one
Yeah, I
opinion
can't
that
find it,
they,
bro. I don't think I ever did a
PC
poll
affirmed
before.
on Benjamin v. State, or Benjamin
And now,
v. Roy v.
that's what I'm saying. It might not be there because I'm demonetized. You know I'm demonetized again on that bullshit, on that fuck ass, fake ass shit. So, I was gonna do a poll for if y'all think he guilty or not, or if somebody find out, let me know because I don't see it. But I ain't gonna pause it. Let me just let it ride. I just want to make sure y'all know that I'm attempting to see this, to find out how the fuck to do that shit. But yeah, let's get back into it.
State that you cited 279.
I ain't got no blunts.
238.
I'm about to smoke
It's a
these
PC
clips.
affirmed. There is a concurrence, and you would concur in part and would reverse in part. I misspoke. All right. So yes, counsel, you want to be heard?
Oh, it may be
Yes,
not.
with regards to, and defense counsel already has the Lamb case, so I'll just provide a printed copy to your honor. Specifically, authentication for the purpose of admission is a relatively low threshold that only requires a prima facie showing that the proper evidence is authentic. I'm reading on the 9th page of notes 5 and 6. Your Honor. Lamb case goes on to state that authentication for the purpose of admission is the ultimate determination of authenticity of the evidence, is a question for the fact finder. Evidence may be authenticated by appearance, content, substance, internal patterns, or other distinctive characteristics taken in conjunction with the circumstances. In addition, the evidence may be authenticated either by using extrinsic evidence or by showing that it meets the requirements for self-authentication. With regards to the evidence that's before your honor, the defense is not agreeing that it's his account. So then the burden is on the state to prove that it's his account. As such, the evidence...
No, listen, y'all, for me, I got demonetized by a false. It was false. The last 2 times I got demonetized, I haven't caught a real charge that I really did since, I think, when I lost my channel. When I lost my channel, if you've been following me for a long time, if you remember one time I lost my whole channel, that shit won't even showing up on YouTube no more. I think I was at like about to be at 15K. Yeah, that when you know what I mean. That was but these last 2 ones have been mistakes. They saying I'm one of them. They were saying I don't even want to say the words, but I swear to God on my right hand. If you look at the video and look at what they shit, it's nowhere in neither one of the shits, bro. It's the AI fucking up. The AI on YouTube is fucked up. They might hear you say something, or even I didn't even say shit. I don't know if they misinterpret shit, or I don't know how to. And it's not nobody flagged me because you can see. So y'all be careful with y'all. You said them buns looking real heavy in that grade. Y'all niggas on her, man. Y'all gonna have her thinking she the shit too. After this case, so I bet AK fans on your channel, bro. What you mean, AK? Academics?
itself shows that it's authentic, as it is the defendant in every single
Shout out Academics, man. That nigga threw me a lot of alley-oops, bro.
one of those videos.
And I ain't-
In terms of the contents of the defendant's statements, they are relevant. They go to the issue at fact of whether or not he committed these 2 homicides. The contents of the questions are important for giving context. An answer without any context doesn't give the fact finder, the jury, any way to meaningfully evaluate the statements. So based on the standard, which is low for authentication, the state has done that by the business record certification and the fact that the email address and everything else will be linked up in other witnesses as well, showing that that was the defendant's particular iCloud account that is the username. It's also important to note, Your Honor, that while the individual doesn't tie it to a specific device, it ties it to a specific individual because it's a unique logon and username and password, just like an email account, that it was used by this defendant.
Thank you. Anything else, Counsel?
Yes, Your Honor. There
She got a
are
little
statements
shaky.
there that,
Y'all
in the
niggas
conversation,
crazy.
that started on October 3rd. October 3rd, this incident occurred on the 26th. The state is making a blanket assertion that these statements go to demonstrate his complicity in these homicides. Each statement has to be identified and the argument has to be made as to each such statement by itself so the court can have a way of evaluating the purported relevance. They can't just say they're relevant to the homicide. That is insufficient. And if they do not identify each particular statement and the relevance of each particular statement, then dumping them all in on some blanket assertion that they're relevant would be error, and it would invite error, and it would prejudice Mr. Demons irreparably.
Come on,
So-
man. Let that boy cook, man. That's a $top lawyer for that. Hey, hey, that nigga ain't going for it. Hey, he don't give a fuck if it's a Snapchat post, or Instagram, a fucking pigeon, was that a carrier pigeon? If that shit ain't got nothing to do with this motherfucking case, why is she showing this shit? And in front of the jury. Yeah, they trying to paint that picture, make him look real, like on some young nigga crazy shit. He remember he doing all that goofy shit. I'ma kill you, whatever he was listening to or doing. I don't even think he said that. The song he was listening to was saying that. He was just looking like on some. That nigga do be looking evil as shit, right?
Context for what? He's having an
Yeah,
argument,
they made a fucking
discussion
sticker, bro.
with somebody on October 3rd. If they're saying that constitutes some plan that establishes premeditation, then let them advance that argument. They have not referenced a single one of those conversations with specificity and advanced some argument that ties it to a fact and issue in this case. So I would say that on the relevance alone, the state fails to make a showing that would allow the court to even properly analyze the question at issue.
Thank you. I'm going to defer ruling out. Take a look at your cases that you just sent. We're going to take a short recess. Mr. Demings, any restroom break? Yes. Can you arrange for a restroom break? Yes. We'll be in recess. Thank you.
Recess. Damn, I need some blunts, bro. I see you, Cat Nell. He said he feeling IQ is quite high. He said feeling IQ quite high. I wonder how long is this? Is this a lunch break or is this a little short jump? Yeah, it's doubt. It's because it's doubt. It's because plain and simple it's doubt. Oh, you know what? Let me skip ahead. Matter of fact, I forgot I'm a little bit. Okay, cool. All right, they just got back in. That's full break. Yeah, fuck that. I forgot we like what 10 minutes behind. Not even 10. We're not even 10 minutes behind. Not anymore. Postmates do blunts? I think I got a J paper over there. I think I got one little paper, like not even a full, like a half, like.
Juries in the jury room.
All right, here we go. They back to the evidence now. Hey, but I ain't gonna lie, bro. That's a top dollar lawyer right there, bro. That nigga gonna argue that shit down. But I even said, I was like, why are they showing these stories that I thought they was gonna show them niggas in the car right before it happened, or you see what I'm saying? I thought they was gonna show some. They keep talking all this social media shit, but they not really showing no hardcore social media evidence. You feel me? The old I did that and all this type shit, and you feel me? That shit ain't. As soon as I seen it, I was like, why they? I was like, oh, they must just want to show the jury when he be on his regular time, and like, you feel me? Like when he be on his regular time, and what type of time he be on? You feel me? Shit. We gonna see.
Hold them up here.
Yeah, he is dressed like Prince, no cap.
Verify them.
Hey, this nigga, hey, idea, you crazy, bro. He is dressed like Prince. Yo. Why y'all saying the female attorney is flirty, yo? I ain't seen now one of them flirt with nobody. They look like some real prosecutors. Oh, you mean Melly's? Yeah, she is, Jai. Like, she too chatty. Like, it's too much fun. Like, I would have told her, like, on the side, like, hey, yo, let's just keep it kind of cool in the like when we go for break, like, hey, yo, don't be like, you know, just don't try to not to be laughing and shit. Like, but he laughing. It's just fun. They're laid back. You feel me?
Is that be changing the business records on that? So, but that's.
She a little too chatty, yo. I'm like, yo, stop doing that, bro. Yeah, he beat this. He gonna be big as Young Thug. He beat this shit. That's why I always looked at him. He reminded me of Young Thug, like his style, type, like how his image. His image reminded me of Thug a lot.
Judge, with regards to this particular video, the second video doesn't have the defendant's picture in it. So just
Said she loving that money. She about to get him out.
Come on. All that extra shit. Maybe the most important shit here.
Oh shit! Please don't. I hope he do not pick that up. Why they trying to kill him? That's why they wanted to show that damn. I'm about to say YouTube. That's why they wanted to show his damn Snapchat. Oh my God, this nigga got a video with a gun.
To take out the part where the gun is there, and then so it would just go from there, and then excise the portion where the gun is shown, because that is showing who is speaking and showing who is then showing the driver's license.
It's fine. The gun should be out. It's not.
Your Honor,
staged before.
could she?
His hand won't on it, though.
articulate the relevance of anything? I mean, I understand.
I heard your argument. I understand it.
Okay.
And I've overruled it.
It is overruled.
Overruled. The only thing I'm doing is on 403 analysis, saying that you can't. I don't see the relevance. I don't see the probative value of the gun and the cash being outweighed by overruled.
Defense counsel is also asking to take
Oh.
out the photo of the song and their titles or whichever else.
Right, I agree. Take it out. Murder on my mind.
Oh. The judge said murder. They about to play Murder on My Mind? Who the fuck is laughing behind the camera? Y'all hear who the fuck is this recording laughing? They like, this nigga cooked. They about to play Murder on My Mind. They really about to play. Oh shit. Damn. No, they trying to do him bad with the guns and the pictures, bro. No, they better not play Murder on My Mind, bro. Why did the judge say Murder on My Mind? Or did somebody ask what that
Just
shit?
need about 5 minutes to fix that video.
Yo, if they play Murder on My
All right,
Mind.
we'll use this. You work on it. Yes, sir, you want to say something?
Yes, Your Honor. So has the court articulated its ruling concerning the visual images, the videos, the pictures, or has the court also decided that all the communications come in without the state asserting a relevancy objection as to each statement, or a relevancy as to each statement?
Counsel, the videos, my understanding, the videos as well as the written conversations, are you articulated and objected, saying they're not relevant and they can't be authenticated and things like that, and the objection is they can't be authenticated, we don't, because how Snapchat works, anybody could have done it, and counsel's suggesting to me that she needs to put it in to show that it's his, because he's the one that's picture on those accounts, it's authenticating. I know I'm the determination of what's authentic, whether it's authentic or not, I'm making that decision, but it appears to me it's going to be argued that it's not his account, or he's not the one that's putting this information on there. That's the tenor of what you're suggesting. So it just seems to me that goes to show who's on the account and whose account it is.
No, I understand that, Your Honor, and please do not understand me to be arguing a decision that the court has made. I'm trying to understand that saying that we're going to put all this in to prove, we're going to put in all these conversations to prove that it's his Snapchat account. Why are they trying to prove that it's his Snapchat account if not to get the very statements in? So if the statements themselves are irrelevant, saying, well, we're going to put in these statements to prove it's his Snapchat account, should they at least articulate why are you trying to prove that it's his Snapchat account?
Because there's a statement in there which there's the state believes is an admission.
Okay, well, if that is the case, then that statement should come in, and if those statements are isolated, then the defense would be in a position to determine whether or not they're going to take the position that it is not his Snapchat account and do a 403 analysis of our own. So if they're saying there are 3 statements in there that constitute admissions, fine. If they might want to put those in, and we might say, okay, we're not going to contest that it's his account, so you don't have to put in all the other stuff that is prejudicial. But they have to at least articulate it and isolate it so that we can make an informed decision.
Thank you, counsel. You didn't bring up the fact that there's it's overly prejudicial. You had a straight relevance objection and authentication objection. I've overruled those objections. When I looked at the video, I said, nobody else, I said, I think that's too prejudicial, not probative of anything, the picture of him with a gun, and I want it out of there. I said the same thing regarding the cash. You did tell me, and I didn't articulate it, that you were concerned about the video with murder on my mind, and I agree with that. That should be out as well. All right? Okay.
Oh, good shit. Good shit. Good shit. Good shit. Because if they would have dropped that Murder on My Mind video, if they would have played that just now, that's what they was about to try to play. He just said no. Thank God, boy. Hold on, let me go back a couple seconds just to make sure that we heard what we heard. If they was going, that was going to be ugly. The video, the lyrics, the topic in the video, that was going to be uglier than anything they just showed.
You did tell me, and I didn't articulate it, that you were concerned about the video with murder on my mind, and I agree with that. That should be out as well. All right? Okay. So that's the ruling. It's the relevance objections overruled. The authentication objection, I admit it, but I don't want the items that I previously discussed being shown to the jury.
Thank you.
Yeah, I mean, show defense counsel.
Boy, hey, listen, I'd be over that bitch sweating. I would have mailed that bitch like, oh my God. If that nigga would have dropped my hit single, Murder on My Fucking Mind, where I'm hypothetically talking about killing my friend, that would have been, yo, shout out to, that's what money do. That's a good lawyer. He sat up there and argued them people down for fucking 20 minutes, I think, just now. 15, 20 minutes, maybe longer than that, because they took a break. Remember they won the argument for that? Yeah.
You go ahead, we're in recess from that. You show whatever you want to show.
All the other ones are already taken out. This is the other one to take out the gun.
And the date, it's a date of these so-called videos on.
Yes, they are on each specific one.
Could I see that diagram again?
Yes, it's there.
Hey man, shout out to everybody in the chat, man. Hey, one time for the snow game, man. Shout out to everybody that hit that like button. If you ain't hit that bitch, elbow drop that bitch right now on them fuck nigga. Hey, on them motherfucker whole ass bitch ass me. God damn it, one time. Hey, listen, if them niggas would have dropped murder on my mind, it would have been murder on everybody's mind in that bitch. Yeah, that would have no, hell no. That would have been dang. That would have been probably the biggest shit so far. Like they actually played it. Like after they say they weren't gonna use none of that type shit, they think they slick. You said they gonna Google that shit at lunch break. that's what I'm saying, bro. It's now that we got the internet, like when you shit like this, it's unfair, bro, because he a big, just like the thug shit. Them people gonna go home. Somebody.
Yes,
Come on over.
you're in recess.
The purpose of this is Snapchat account.
Snapchat.
Can you at least identify what you think is a confession in there? Identify it, but I don't understand why you would not identify it, because then you might not have an objection to the rest.
But you probably still want to know.
Yeah, but then it would be admissible based on her theory.
I got murder on my mind. It's a fucking homicide. Yo, if that shit would have dropped in the studio, it's a fucking homicide. Blood all on my shirt. Bro, if I was Melly and they played that shit, I would have passed out. I would have did a Suge Knight and fell out in that bitch. And they had to cancel court for it. I would have stopped. I would have did that shit instantly, nigga. Oh my God, he's having a heart attack. I would have faked the fucking. I'm telling you, nigga. Hell no.
Take him out. If you take him out, don't take him out, man.
He said, take it out.
I don't need to.
Bro, I would have passed out in that bitch. I would have made them shut court down for the whole day. They would have dropped murder on my mind in that motherfucker. It's a fucking homicide. I didn't even mean to do it. He just caught me by surprise. Like that shit sound like an audio confession. But even though that's happened before, but that would have been horrendous, bro.
That if you think there are confessions in there or statements,
I would have felt out like Suge Knight in that motherfucker, nigga.
this is the only one.
This page.
I would have failed the fuck. Y'all would have seen young. Hey, IQ would have fell out in that bitch.
You're not telling me what I'm saying. I'm saying identify what you want in because
Oh, they having a see. So what they're doing now? They're having a polite argument / debate about this fucking shit. So I'm guessing she got some kind of memes. It might not. She might got not just the whole music video, but like memes of him rapping it, or it looked like it was an Instagram live too. That it looked like they had when I was looking in the folder that they were showing. I thought I seen an Instagram live video.
I think it's all admissible to prove that it's his account. If we're not contesting that it's his account, then you're putting in the form of information. Identify what you want in so that we can make an informed decision.
She don't even know.
If you violate the judge's order, then it's a you problem. I don't need to review it.
It sounds like she don't really know what she want to point out in the video.
Yes.
Okay. I'm not trying to get I know you're mad. It's just problems.
Council's going to take you a few minutes.
The video's
Yes, we need a
done.
few minutes. I think Mr. Allison is taking a pizza. And we just wanted to be clear that if we
We're in
are...
recess now, so you want to be on the record again?
Yes, just so I can complete the record on this one point.
Let the record reflect the presence of the defendant, his counsel, the assistant state attorney, jurors, and jury. Yes, sir?
The state is asserting that among the conversations in State's Exhibit, what was it? Mark for identification?
Jay?
Triple J.
Triple J, that there are certain conversations or certain exchanges which she believes relate to facts at issue, and that the rest of them she is using to authenticate or to establish that it is the account of Mr. Demons. I'm just putting on the record that the...
Jeff, Melly does have a co-defendant, but he has a separate trial. His co-defendant is Ryan W. Bortland. That's his, but they were saying he got a separate trial. So I'm not sure if him having a separate trial, can he come testify against, or, you know what I mean? I don't know. I don't think so. I don't know though. But we're gonna see that go too. You hear me?
The defense would be willing, if
Yeah.
she does isolate those conversations, to consider not objecting or not making the claim that it's not his account, so that she can get in whatever she deems is relevant, and we can avoid the prejudice of the remaining contents that she intends to put in that is not relevant, and she only intends to put in to establish that it's his account. I just wanted it to be clear that that is an offer that we have tendered to the state, and we're articulating for the court. Thank you.
Thank you. What says the state?
Your Honor, the state is going forward that the state has to convince the jury beyond a reasonable doubt as to the authenticity and who those messages link to. And that was the way defense counsel indicated from the beginning that that is how the state needed to proceed. So at this point, the state would enter the evidence as it is currently put.
Thank you. Can I see you, please? Because there's whole conversations with Ms. Mariah Hamilton that really, that goes to authenticate whose account it is, but I don't know that it does anything other than that. And can I see the exchange again, please? JJJ.
Oh, I left it right there, I'm sorry.
And Mr. Edelstein asked me to print another copy for him, so I'm trying to work on that.
I'm sorry.
I apologize.
No, it's my fault, I accept the responsibility. Federal court, I get 2 or 3 points out my guideline sentence.
Smash them likes, gang. Get them likes up. Smash them likes, my niggas. Like I said, I do want to say shout out to the cameraman, because Hey, YSL cameraman, you can learn a lot from this nigga. This nigga getting all the good pictures, the angles, the shots. This nigga had to have some cinematic work or something. This nigga doing, whoever's controlling these cameras, they doing that. They laughing and shit behind the camera, but fuck all that. The angles is great, man. That palm itching. I mean, that money coming. That nigga look tired as shit like me. I'm tired. My back hurting. Hey, you know what's crazy, bro? Even about this hat. You know the only reason I bought this hat, I didn't buy this hat because I wanted it. I bought it because I went to a play. I went to the New Jack City remake play shit, and I think my hair wasn't done, and this was like the only hat that was in the nearby store. I was like, damn. Yeah, that's the only reason I bought this hat, bro. You know it's Dolph over this bitch, bro. Honestly, I'm about to retire it. Don't trip. I'm retiring. What the fuck is so funny? What she said? What is always so funny, bro? Yeah, New Jack City remake. It had Cool G rap in it. Cool G rap. G Money from the actual New Jack City. He played himself. Tretch from Naughty by Nature. He played Nino Brown. Tori Hart, she played Rockabye Baby. Some new guy played Chris Rock character Pookie. Yeah, hell yeah, it was dope as fuck. It was dope. Yeah, I actually went where that shooting happened in, at the high school graduation. That's where I went to. It's called the Altria Theater and shit. You know what I'm saying? It's a lot of big shows come down and shit. Damien, what's good, gang? What's the business, my dog? Oh, shit, that's my nigga Langston's Hill. What's good, gang? What you been on? Yeah, what's the fuck is so funny? I'm trying to figure out my damn self. Like, why is everything? Look, he like, hey, nigga, I'm gonna give you a extra $2 million if you make sure.
Let's get back on record. Again, let the record reflect the approach of the defendant, his counsel, and the assistant state attorney, jury in the jury room. I'm not fully understanding everything that you're saying, Mr. Howard. You're telling me that you're not objecting to the Snapchat conversations. You're not going to argue to the jury in some way, shape, or form that it's not him if it's limited to what the state is suggesting, so the conversations between he and his girlfriend and things like that wouldn't come in. Is that what you're saying?
I am saying, Your Honor, that if we need to be able to make an informed decision. So I'm saying that we need to know what she deems to be relevant, and then when we know that, then we can make the decision that, okay, well, we think that it makes more sense to not make the argument that it might not be his account,
Okay.
so that she can get her evidence in, but to get the rest in. Your Honor,
No problem. We'll just leave it the way it is.
Okay. There may be another issue, not as though you don't have enough on your plate here. We have reason to believe that the state intends to call Miss Felicia Holmes in this next session. And there is the law in this jurisdiction and in this state is that a witness shall not be called merely to be impeached.
Whoa. Who is Felicia? Whoa. A witness is going to be called to impeach. What the fuck is going on? When you hear somebody say we have or lawyers and police and shit, we have reason to believe, that means they actually already know. They gotta. What the fuck is going on here, gang? Oh shit, yeah, he finding them loopholes like a motherfucker. Hold on, I know you got a lot on your plate, Judge, but look, this shit ain't right neither. What's up with this?
I don't know that is the case or not, but I'm concerned with trying to unring a bell. The theory is essentially a statement that the state knows that they will not be able to elicit, and they seek to only impeach their own witness by a prior inconsistent statement, amounts to hearsay because it's being offered for the truth of the matter asserted. So when the state calls a witness that they know is about to, and these are instances when a witness says A and then recants and says B, and the state wants to get A in and knows that the witness's current position is B. To put the witness up there to say B and then impeach them with A is improper. I have here some cases, a few, for the court, stand for that position. Dudley v. State, 545 Southern 2nd, 857, Florida Supreme Court, 1989. Felton v. State, 120 Southern 3rd, 126.
Case law.
Florida 4th DCA, 2013. Curtis v. State, 876 Southern 2nd, 13. Southern 2nd, 13. And that's First DCA, 2004. And there are many others. And may I hand up? I have highlighted copies of the cases.
You have them for a state as well?
I do indeed. If I may.
Take a look, whatever you have.
Thank you, sir. Now, I understand that this might be a little bit premature to the extent that I don't know for what purpose they seek to call Ms. Hamilton, but I don't want to be in a situation where we're trying to unring a bell when we are in a position to avoid that prejudice from occurring. So I'm alerting to the court to that possibility, and if that is in any way the state's intention, I would ask that it be voiced now so that the court is in a position to make that assertion. And they don't even need to voice it to us. They can voice it to the court outside our presence.
And who's your next witness?
Felicia Holmes.
Oh! She said Felicia Holmes. You know this nigga, I like this dude. I like him. He already had that. He did that last night. He had folders for everybody. Look, I got a copy for everybody right here. This is what I was talking. This nigga. Hold on. She said that was the next witness. His timing is impeccable, nigga.
You need to voice it to us. They can voice it to the court outside.
Shit like a movie, nigga.
Our presence.
And who's your next witness?
Felicia Holmes.
All right, so it is Ms. Holmes? And,
Not Miss Hamilton.
Felicia Holmes, sorry.
And what do you anticipate Ms. Holmes say?
Judge, I believe she will testify consistently with her previous statement that she gave in 2018. And I'm very familiar with the case law, and I would agree with counsel that that the state cannot call a witness just for the purpose of impeachment. However, I'd also direct Your Honor's attention to 803 subsection 5, past recollection recorded, in which a witness who no longer has a memory of an event but has previously given a memorandum or record as to what happened, they may testify as to lay a predicate as to that, and then that memorandum or record could be read into the record in support thereof.
So are you telling me that you believe that your witness is not going to remember what you said previously?
I believe there is instances in which her memory is no longer available and that she would...
What? My bad, gang. I had to refresh that. You did. Let's get back to it, man. I had to refresh that. Let me give it a couple seconds. I had to refresh it, y'all. My fault. It was lagging a little bit. You know, every so often I gotta refresh it just to keep it somewhat. God damn it. This shit started getting robotic. But let's get back.
Testify that she was truthful to law enforcement at the time of the statement in December of 2018, that she now no longer remembers because it has been so long, and that was a time when her memory was better. It was closer in time to the time of the offense. It was within 2 months of the offense occurring and the events of which she witnessed, so that would be admissible under 803 sub 5.
So you're telling me you've spoken with her, did a pretrial discussion with her, and she said she has no memory of what she said at the time?
There are parts of which the statement she does not recall. That is correct.
May I retort?
Sure.
Okay. A couple of things. One, as with every other witness, the way that you prepare your witness is you refresh their recollection before you call them to the stand. So the notion that this witness is going, that all the state has been able to glean is that Ms. Holmes no longer recalls something which she said several years ago, and the state has not sought to refresh her recollection, in which case she would have been prepared to testify. Then the pretext that she comes in here and says something different, and then she impeaches her with a prior consistent statement, claiming that it's an effort to refresh her recollection, is disingenuous and in bad faith. And if that were able to be done, then this body of law would not exist. We also took her deposition, Ms. Holmes, on December 14th of 2022. No, that's not it. Much more recent than that, no?
22. Yeah.
December 2022, in which Ms. Holmes receded from the statements to which the state refers firmly and unequivocally. And the state is therefore, I think the language used in a lot of the cases that I have cited and in a lot of cases on the subject is the state needs to be surprised during the course of its examination at the contents of the statement in order to thereafter impeach their own witness. This notion that, oh yeah, well, she forgot, and while we talked to her, we learned that she forgot, and instead of refreshing her recollection, as we did with every other witness that we put forth prior to in preparation for her testimony, we're going to wait and do it on the stand by impeaching her with a prior and consistent statement is a pretext, it's in bad faith, and it's improper. It's prejudicial, and it should not be permitted. Essentially, it amounts to hearsay, because it's a prior and consistent statement or an out-of-court statement that is going to be used to prove the truth of the matter asserted, which is different from impeachment, where it's not used to prove the matter asserted, it's just introduced to prove that you said something different.
Shout out to everybody in the chat, man. You said that Jeff said that the lawyer don't be playing. Yeah, damn right. Shout out to everybody in the chat. Please smash that like button. Let's get this bitch busting. I know the lag is a little laggish, you know what I'm saying? But they trying to bring Fredo. If I see Fredo, I think Fredo Bangs
at a different time.
I said no,
I
though.
think these cases are clear. And if that's what they intend to come and do, again, they're inviting error, and I'm alerting the court and the state to it before this miscarriage of justice ensues.
Thank you. Anything else, ma'am?
Just the record's clear in her deposition and counted. She says, I don't remember, or I can't remember, approximately 26 times. The witness has been reviewing her statements and depositions for the past 2 days, and she still persists in saying she does not remember, so that 9803 would be an appropriate remedy to enter the testimony from the prior scene.
By the way, Your Honor, I've highlighted those cases for ease of reference. Or at least 2 of the 3.
And what's her statement, counsel?
What is her statement?
Right.
This was previously provided to defense counsel.
Oh, just give me a synopsis.
Yes,
What is it that you want, or what you believe she's going to testify to, or if she doesn't remember what you are going to try to refresh her recollection?
So she says that she was woken up at 4 in the morning. Her daughter was screaming. The daughter was on FaceTime with Melly. Mr. Dimmons then says he was saying that meaning Mr. Dimmons, was saying that someone just shot the car up and was trying to shoot them. He then said there's like a car coming behind them and he's hiding. So then she asks Mr. Dimmons, "Are you okay?" His response was, "I'm okay." She then asks him where are Sack and Juvie, the common nicknames of the 2 victims, and he said, "I don't know if they're in the car. I think they're dead." So she then says, "You think they're dead?" She then goes through and describes her actions and conduct. She said that she called his mother, Jamie. Oh, I wouldn't go into the content.
Oh, so that was one of them, one of the guys' mom. I remember they was talking about that the other day, that when he called, who I think it was it Sack Chaser mom or Juvie mom? He called one of their mom right when it happened and was saying all that, like, "Oh, I think they dead in the car. Somebody just shot at the car." Da, 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 da. The day of when the situation took place, you know what I'm saying? Shree.
Of that conversation, because that would be hearsay. She then describes what she sees, which was her daughter on the phone on FaceTime with Mr. Dimmons. She then says that she's going to come down, and then she describes her actions, that she hopped in the car and came down to South Florida. She said that at that point she asked and called Mr. Dimmons again, spoke with him and said I'm at my friend Fredo's house. Fredo picked me up. So we went to Fredo's house. Then she describes that Fredo lives over in the same neighborhood that Melly lives in, and that she went in through another gate from the same.
Wow, so he really did go to fucking Fredo house, bro. Fredo Bang, if y'all know who you talking about. They lived in the same fucking neighborhood, bro. And he went over there after. Yo. But Fredo said he ain't. But hold on, Fredo was like, damn, this shit's lagging like a motherfucker. God damn, the lag is real as a motherfucker. My bad, y'all. Y'all see, it was working. I don't know what be going on. It should be working, and then I changed nothing, y'all. I only sat here for like an hour. But that's crazy, bro. Yo. Alright, my bad, y'all. I had to get that straight, man. I just turned my motherfucking camera off, so y'all should be able to hear me, right?
Timed meaning Mariah Hamilton, the daughter of Felicia Holmes, FaceTimed. And Cher answered at that point was, he FaceTimed my daughter from the 772 number. So then she continues on, unless he got rid of that phone. He FaceTimed my daughter that morning at 4 in the morning, yeah. Then she's asked, what's her daughter's number? And she gives her daughter's phone number at that time, 321-506-1313. Then it continues on, and so the law enforcement officer asks and says, I have his phone records, meaning that of Mr. Demons, and he never called, there was never. Then she identifies the phone number as, you have the 772-713-9807 number. She then continues on, he called and FaceTimed with, I talked to him on FaceTime. Then there's another incident, I don't know if potentially this could be possibly admissible, depending on the testimony. She says that they told me there were other guys in the studio, and he was saying that the other guys got mad, but they never said who was at the studio.
But you're telling me, counsel, that you spoke with the witness prior to, and the witness is not saying she didn't say X, Y, and Z. She's saying she doesn't remember
Correct.
The incident.
In the presence of the witness and her attorney.
Thank you.
Your Honor, before I address this.
Oh, it's smooth. Okay.
I just want to.
Yeah, I'm still here, y'all. I turned my camera off because that shit. I know for a fact maybe I just got to get my graphics card or some shit. I got to get some kind of add-on to make this shit. I think that's what it is, because I ain't hooked this laptop at all. I just bought this shit as soon as I got monetized. I bought this with like my first YouTube check. You know what I'm saying? I took like 200 and goddamn, how much was this shit? $220, and went and bought this shit. So I'm gonna have to upgrade and shit. But shout out to everybody in the chat. What up, Benny? Please smash that like button, and let's get back into it, man. Shout out Benny the Jet, man. Y'all go sub up, man.
Put into the record some of the language that I think is most pertinent in the Curtis case, 876 Southern 2nd 113, which was a First District case in 2004. This is the language. It says, Florida allows litigants to impeach their own witnesses, but that does not necessarily resolve the constitutional problem identified in Chambers, which is another case that's referenced. Although a witness may be impeached in Florida by any party, including the party calling the witness pursuant to Section 90.608 Florida statute, it is still improper under Florida law for a party to call a witness merely as a device to place the impeaching testimony before the jury. That is Curtis. In the Florida Supreme Court of Dudley, the language that we're relying on, the case says, one major issue requiring our consideration concerns the calling of Robert Bennett as a court witness and the presentation by the state of his prior inconsistent statement as substantive evidence. There's language further down. It says, in a similar situation, the First District Court of Appeals in Austin v. State 461 Southern 2nd 1380 Florida 1st District 1984 found that although a witness's hostility towards the parties may justify the trial court's exercise of discretion in calling the witness as a court witness, to call a witness only to elicit prior unsworn statements for the purpose of proving the truth of the prior statement is error. The district court stated, under the circumstances of this case, it was impermissible to use the expedient of calling the witness as a court witness under Section 90.615 for the purpose of eliciting his prior inconsistent statement, either for impeachment purposes or as substantive evidence. To conclude otherwise would permit indirectly that which may not be done directly. Further language from that case says, the fact that a witness may be hostile or unwilling does not mean that he is adverse. In order to be regarded as adverse under this section, the witness must give testimony prejudicial to the cause of the party calling it. So if you know that's what's coming in to begin with, there is no surprise. And then in the Felton v. State, 120 Southern 3rd, 126, 4th District, 2013. The language that we're relying on says, in Ruff v. State, 31 Southern 3rd, 833, Florida, 4th DCA, 2010, this court explained, our Supreme Court recognized that consistent with federal precedent, a risk of abuse occurs when a prosecutor calls a witness who has previously given a statement implicating the defendant, but who has since repudiated that statement. In such cases, the purpose of calling the witness must be examined along with the balancing analysis under Federal Rule 403 to weigh the prejudice over the probative value of the evidence. Generally, however, if a party, and that's citing to Morton v. State, 689, Southern 2nd, 259, Florida, 1997, that was receded from.
I told y'all, man, this lawyer, he's a professional, bro. That's how I recognized it. Me just fighting my cases and shit like that, like especially being locked up, fighting your cases, having to go to the law library and shit. You always learn early on to like beat cases and win and beat appeals and beat shit like that. The lawyer has to use case law a lot of the times, which is old cases that are similar to the case that you're doing that can prove, or what's the good word for it, that can substantiate shit that you might not agree with or you might agree with in the case. You know what I mean? I'm not a lawyer, so it's kind of hard to read, but you know what I'm saying, if you know what I mean. It's basically like saying, hey, if Michael Jones can't shoot anybody, then this guy can't. If Michael Jones in 1997 at the store case, he got in trouble for shooting somebody, then this guy in today should get in trouble for shooting somebody. It's basically, you see what I'm saying? I'm trying to put it in words, in layman's terms, but yeah.
On other grounds. Generally, however, if a party knowingly calls a witness for the primary purpose of introducing a prior statement which otherwise would be inadmissible, impeachment should ordinarily be excluded. That is exactly what is taking place here. There's no failure of recollection. If the state, first of all, if somebody gets a call at 4 a.m. concerning a murder that occurred, you don't forget it. This notion that she forgot and she is now going to refresh her recollection by reading a statement into evidence that is impermissible, hearsay, is a pretext, and it is a 403 violation, and it is a violation of well-established law in this state that I've just articulated. And if the state was unable to refresh her recollection of such a significant event during preparation, the notion that she is now just going to read the statement into evidence on some pretext is a miscarriage of justice. If she has a witness, she has a witness. If she doesn't, and she knows she doesn't, calling the witness to impeach them by essentially introducing hearsay testimony is improper. The deposition that we took made clear that she she was receding from the statements that she made, and she gave explanations for why she made statements that she made. This is not a situation of failing recollection. This is a situation where they're trying to put in impermissible evidence under a pretext. And we object.
All right, anything else? Madam State?
No, Your Honor.
So we're going to bring the in, we're going to see where it goes. All right, I understand what the objection is. God bless. I understand what the objection is. We'll see where it goes.
All right.
All right, let's bring the jury in.
Yo, this nigga Melly is fucking crazy, bro. Why he was staring at the camera like that? He seen it. He seen the camera. He finally seen that motherfucker today. Melly funny as shit, bro. He did that for the thumbnails. He know what he doing.
No, I don't have
But those aren't the same statements that we're looking at.
No, phone call, she's from the Sure.
Your Honor, I'm not sure we're ready for the jury. We're being handed totally different information that they plan to
Gary, hold on.
put in through this witness.
I'm sorry, what were you handed, counsel?
Counsel has been handed and was previously provided a portion of the defendant's phone extraction. This particular summary, and there was a notice of intent to rely on summaries filed prior in this case by the state. This particular summary details the conversations between the defendant under the 772-713-9807 phone number, conversations with Mariah Hamilton, the witness's daughter, and her cell phone on that, as well as conversations with Miss Holmes herself, who is a party to some of these conversations. There was a group chat going on in which she is able to authenticate that the phone number, the 772-713-9807, which is reflected in those records, was being used by the defendant at times before, after, and during the homicide in question.
I take it these are just being introduced to identify the 9807 phone number
As well
as being a phone that Mr. Demons used.
Correct. So, and if there are two first pages, because if you look at them there's a section in green where he's telling Miss Hamilton this will be his third birthday he's been locked up on. I agree that that would be prejudicial to the defendant, so I created a version in which that specific item is taken out. So if you look at the green birthday and then just take the first page and the second page, or duplicates of one another, with the exception of that alteration.
I'm not sure I understand. It sounds like you're saying these are conversations that took place while he was incarcerated?
No. He knew and was made aware he was going to be serving a sentence in Lee County, because that was a negotiated resolution. So instead of saying third birthday I'm going to be locked up on, WTF, instead I just put third birthday, and then her response on that.
To the extent that Ms. Holmes is not a party to the conversations, she can't authenticate. Now, I understand the state is saying that there are certain conversations which were a group conversation between Mr. Demons, Ms. Holmes, and Ms. Hamilton.
Correct.
Are all of those? Do all of the conversations in that exhibit fit that description?
No, she's also identifying her daughter's phone number in this other one.
Identifying her daughter's phone number, Your Honor, doesn't identify the participants of a conversation.
And so here are the other ones in which, for example, there is other participants in which her daughter's phone number is included with the defendant, the 9807 phone number, the manager's phone number, the little brother's phone number, the phone number of Miss Janie Keene is on there. Then there's the phone number down here that's part of the third part, where it is the defendant's phone number, Miss Hamilton, and Miss Holmes that are all listed on there.
And the state has not articulated a relevance of even establishing Ms. Holmes or Ms. Hamilton's phone number. For what purpose? I think I heard the state indicate a little while ago that there was no record, according to the detective, of this alleged phone call. So it's not as though they're going to say, see, here's a phone call between this number and that, because they don't have a record of it. So establishing the phone number, for what purpose? I they might as well establish my phone number. What does it matter? If it can't be tied up, or if it's not going to be tied up to some other record that they have. Saying that we want to put it in to show her phone number. Show her phone number for what? What does Ms. Hamilton's phone number have to do with anything? They can proffer it, but they have not yet articulated it. And there's several phone conversations there that do not involve the witness that they're about to call, and for those phone conversations to come in through that witness is just improper. How does she even lay the predicate to that?
Yes, ma'am, I don't know what you're trying to do.
So in terms of authenticating the phone numbers and laying the foundation for when these come in later on, I don't intend to publish these at this point. This is a predicate question that has to be established by this witness to show the phone numbers, the participants, the identity of those individuals, and some of the items in them.
When you say participants,
Correct.
does she know who the participants are? She's a party to this?
She is one of the parties. For example, one of the specific items that's talked about is the defendant killed a pet. It was a snake that died. She knows and knows who had that snake, the circumstances of how it was killed, so she can authenticate based on the content who was on the other side, who was using that phone. The point of contention is who had the 772-713-9807 phone number at the time of the homicide.
Okay, thank you. All right, so we're going to just see where it goes. You make whatever objections you think are appropriate.
Okay, sir. Thank you.
I'm sorry, something funny?
Pardon me?
Something funny?
Not that you're ruling. You're not
Oh.
And I hope you don't get that impression.
Let's bring the jury.
Thank you.
Oh shit, the judge ain't feeling him, bro. He said something funny. Then the dude said, what? He said, nigga, it's something funny. Oh, that's not good, bro. He need to chill out. Don't be so. You seen how Melly was looking like, hey, what you doing, nigga? Don't curse that, don't. Judge say, nigga, yo. Something funny. It's because they over there always smiling. See, the judge recognized that shit, bro. That's why I said they got to stop taking shit as a game and just being all cool and like, yo.
Jury entering. Ladies and gentlemen, thank you. Please be seated. Let the record reflect the presence of the defendant, his attorneys, assistant state attorney, the jury. Ladies and gentlemen, I apologize for the delay. My fault. Anybody else, I apologize for that. In any event, I think we're ready to proceed. So, Madam State, want to call your next witness, please?
State will call Felicia Holmes. And you're at this time the state offered state triple J, which was previously shown to defense. And your 9803.6 is a business record. And request.
Any additional objections, counsel?
No additional objections, but objecting on the grounds previously raised.
Thank you. To be admitted.
Thank you.
State's triple J will be marked state 61.
61? 61, thank you.
Counsel, where's your witness?
They were down the hall. With your permission, I send you a text message, Your Honor?
Yes. Good morning. Are you Ms. Holmes?
Yes, I am.
Welcome.
Hello.
Come on up here. This is our witness stand. Ms. Holmes, when you get there, what I'd like you to do is remain standing. Raise your right hand and be sworn. You get the first down. Thank you. Raise your right hand and be sworn.
Do you solemnly swear or affirm the testimony you should give this case shall be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Please state your full legal name for the record.
Alicia Ashe Holmes,
Please spell your first and last name for the court reporter.
FELICIA, HOLMZ.
Please have a seat. Ms. Holmes?
Yes, sir.
That microphone in front of you does not move back and forth, though. Just up or down, but not back.
Hey, shout out everybody in the chat, man. It's the boy out to the queue. I'm still here in the back, man. I just cut my camera off so the visual can go smooth for y'all. But did you see the way he looked at her when she came in the room? That's his ex-girlfriend's mom right there. So you know they had a close relationship and whatnot. Shout out Brazil, man. Van. Shout out all my people in Brazil, man. You feel me? All my South American folks, man. What up? You feel?
Okay.
Smash that like. Smash the like.
Thank you. Good morning, Ms. Holmes.
Good morning.
How are you today?
Not good.
Are you cold?
No, I'm just, you know, I don't feel comfortable.
Are you nervous?
I feel threatened.
What?
So, Ms. Holmes, I want to start and just talk about who you are.
Yes.
Ms. Holmes, do you have any children?
Yes, I do.
Can you tell the ladies and gentlemen of the jury who is Mariah Hamilton?
My youngest daughter.
And how old is Mariah?
She's 22 right now.
And Mariah, did she have a romantic relationship with someone named Jamel Denons, also known as Ynw Melly?
Yes, she did.
When was she involved in that romantic relationship with Melly?
I think it may be like 2016 or so till maybe 2019, 20.
Okay. Did you have the opportunity to meet Mr. Denons?
Yes, I did.
What did you refer to him as?
I call him Ynw Melly.
Do you see him here in the courtroom?
Yes, I do.
Where is he?
He's right here.
And what's he wearing?
A white turtleneck and a gray jacket.
Your Honor, may the record reflect an in-court identification of the defendant.
Yes, the record will reflect the in-court identification of the defendant.
So in October of 2018, had you met the defendant prior?
Yes, I did.
How many times had you met him in person prior to that?
A couple.
A couple?
Maybe two maybe.
Okay. Did you follow him on social media?
I'm not sure. In 2018, I wasn't. No.
Okay. Did you know if he had social media at that time?
I didn't. No, I didn't.
Okay. Did you have a social media account at that time?
Yes, I did.
And what was your social media handle?
I'm sorry.
What was your social media name?
My name? For which one?
For Instagram.
Instagram. It's like Bling Queen 258.
Okay. Did you have a Snapchat at that time?
I don't think so. If I did, I may have.
Okay. What about your daughter? Did she have an Instagram?
I'm pretty sure she did.
Okay. Did she have Snapchat?
I'm pretty sure she did.
Okay. So I'm going to show you what's been already admitted into evidence as State 61. There's a couple of videos and things on that I would like to ask you to ask some questions about.
Your Honor, we'd object as to the predicate being laid for this witness to testify to any of this material.
Thank you. Objection noted.
So I'm showing you what is titled Memories 2018 October 9th 4:58 UTC, Melly, Montana. Can you see that picture there on your screen?
Yes, I can.
Okay. Who is the female over there?
That's my daughter,
And which daughter is that?
Mariah.
Okay. Who else is in that photograph with her?
That's Chanel.
I want to go here to this image. This is 2018, November 11th, 23:53:26 UTC. Again, Melly, Montana. Who is pictured in this photograph?
My daughter, Mariah.
Do you recognize the individual in the back?
No.
Prior to coming into court yesterday, were you shown two photographs of the alleged victims in this case?
Yes, I was.
Were you able to identify them?
No, I was not.
In terms of your relationship with Anthony Williams and Chris Thomas, how many times have you met them?
Maybe Stack maybe twice. Judy maybe once.
And do you know them by their real names?
No, I don't.
How did you refer to them?
Stack and Judy.
Okay. So I want to go forward to some of the videos in this particular exhibit, specifically Memories 2018, October 18th, 2:17:49 UTC. Start with this one. I'm going
Before
to...
we tell me, all that extra shit, and like, they leave the most important shit here.
So the image that is shown there, do you recognize the person in that driver's license?
It's blurry.
Okay. I'm going to show you another video, the next one
The most
here.
important shit here. Like, get right there, like, you know you come back.
Whose driver's license is that?
That's my daughter.
The conversations and things that on there, do you recognize the voice?
I didn't really listen. I mean, you have to play it again.
Sure.
Before we tell me, all that extra shit, and like, they leave the most important shit here.
Do you recognize the person who's speaking in that video?
Yes, I do.
Who is that?
That's Chanel.
Okay. So I want to go back to October 26th of 2018. Where were you living?
I was living in Cocoa.
And my geography is terrible, I think. How far away is Cocoa from Broward County?
About 3-4 hours.
What do you do for a living?
I'm a registered nurse.
Were you a registered nurse at that time as well?
Yes, I was.
Did you know the defendant's mother?
Yes, I do.
And who is she?
Jamie.
Had you met her prior to October 26th of 2018?
Yes, I did.
Have you communicated with her?
Yes, I did.
Did you have a phone number for her?
I'm pretty sure I probably did.
I'm not asking you to...
I don't know if I did or not. I can't remember.
Okay. So I want to go forward on October 26th of 2018 and talk about that early...
Yeah, don't say nothing, Spirit. Don't say nothing, bro. Don't blow no surprises. It's behind for a reason for the people that's behind. You know what I'm saying? But don't say nothing, bro. Don't say nothing, y'all. Smash that like. Shout out to everybody in the chat. Please smash that like, gang. Smash that like, gang.
Did you receive or hear a phone call or FaceTime video call in which the defendant was a participant?
I did overhear. I'm not quite sure exactly the context of the call, but I did overhear the phone call.
Okay. Tell the ladies and gentlemen of the jury what woke you up that morning.
Just hearing my daughter's voice.
Okay. What was the tone of her voice without saying what she said?
I don't remember. I don't remember.
Okay. Do you remember anything the defendant said on that video?
Not verbatim, no, I don't.
Okay. Did you have an opportunity to read the statement you gave in 2018?
I read the statement.
Okay.
I don't recall. I don't remember anything from that statement, but I do remember my deposition from December 22.
So the deposition, that would have been 6 months ago?
Yes.
Okay. I want to go, and when you spoke, you remember speaking with law enforcement in December of 2018?
I remember speaking with them, but I don't remember what they look like. I don't remember their names, but I do remember talking to someone.
Okay. So, Ms. Holmes, I want to ask you, were you honest and truthful with law enforcement when you spoke with them?
I would hope so. I mean, it was 2018. I went through a lot during that year, so I'm not sure where my mindset was at that time.
Did you lie to law enforcement?
I would hope not. I don't remember what I said back. It was like 5 years ago.
Oh, of course. I understand it's been a long time. So in terms of the time frame, that was closer in time to the incident of October 26th of 2018?
If that's where you guys are saying it is.
You don't even remember?
I don't remember. Like I said, 2018 was a very hard year for me. My husband just went to prison. My father died. I had a lot going on, so
Of course.
I was really out of it.
Okay. And in terms of your conversations with the police officers that morning?
Yes. I do remember that they kind of bullied me and threatened my daughter to take her to jail for accessory after the fact. I do remember that.
Yes. And in terms of the statements that you made about what happened,
Yeah.
you don't have any recollection of
No.
that? Did you read this statement multiple times?
I looked at it and I just didn't recall it, and I don't know.
And so you indicated you hoped you were truthful with law enforcement.
Yes, I did.
I have to ask you to be more definitive. Were you truthful?
I don't remember what I said to them back then, so if I was to tell you something now, I could be lying. I don't want to lie on the stand because you're going to take me to jail. So I'm saying what you want me to say.
I do not want you to say anything. I want you to tell the truth.
Okay, that's what I'm doing.
Okay. So, Ms. Holmes, with regards to that day, did you lie to law enforcement?
Objection, asked and answered.
Excuse me, overruled. Repeat your question.
I don't remember.
Excuse me,
Yes, sir.
only one person can talk at a time, and there was an objection. I just wanted to
Okay.
be clear. All right, you asked your question again.
Okay. So, Ms. Holmes, did you lie to law enforcement?
Not that I recall.
Okay.
I don't remember.
Okay. Going forward to the events of that day,
Yes.
when you heard that phone call, where were you?
I'm home.
Okay. Where was home in Cocoa?
Cocoa.
Who else was there at your house?
My kids.
When you heard the phone call, did you hear what had allegedly happened?
I heard that there might have been a shooting.
Okay. Did you see any pictures or videos of anyone that was injured at that point?
No, I did not.
Did you see the defendant on the screen of that video call?
I saw his face, yes.
In terms of the method of communication, do you know if it was a FaceTime call?
I assumed it was FaceTime. I couldn't say for sure what kind of call it was.
At the time of October of 2018 through December of 2018, do you know the defendant's phone number?
No, I don't.
Do you recall today what the defendant's phone number was?
No, I don't.
Okay. In terms of the information and stuff that you have regarding that phone number, was that saved in your phone at that time?
It may have been. I can't remember.
Do you remember what phone number you had?
No, I don't. No, I don't.
So, Ms. Holmes, to go back in terms of looking at your statement or any of the other things, refresh your recollection as to what the defendant's phone number was and what you had at that time.
I'm sorry, could you repeat the question?
Sure. You said you didn't remember the defendant's phone number.
No, I don't.
Would looking at a copy of your statement help refresh your memory as to what?
No, I don't think it won't.
Okay. Would you like to try to do so?
You have to look at it for you, sure.
Okay. And so, counsel, on for the record, I'm showing her page 3 of 8. And so I'm going to ask you, Ms. Holmes, to just read this part silently to yourself.
Okay.
And I'm going to read from, we're going to start here, this, and through here, okay? Silently to yourself. When reviewing that, does that refresh your recollection?
No, it doesn't.
Your Honor, pursuant to 90.8035, the state would move at this time to read into the record the relevant portions.
Objection, Your Honor.
Can I see, please?
Yes, Your Honor.
Ladies and gentlemen, it's 12 o'clock. Let's take our lunch and recess. Don't discuss the case. Don't form any opinion about the case. Don't allow anyone to discuss the case in the presence. And certainly no research, all right? Please rotate on your chair. Sorry for the delay. What time? Let's say 1:30. Thank you.
Oh, sorry.
Okay, thank you.
Thank you. Let the record reflect the jury stepped out. Counsel remain along with the defendant, assistant state attorneys, and our witness. Madam, you want to step outside for a minute? Thank you. Just wait outside. Thank you. So what do you anticipate this?
That her answer would start with, he FaceTimed my daughter from the 772 number. Question, yeah. Answer, unless he got rid of that phone. He FaceTimed my daughter that morning at 4 a.m. in the morning, yeah. Question, what's your daughter's number? Her number is 506-321-506-1313. But she may have another number because I changed her. She lost her cell phone and got another number. Her old number was, question, no, cuz, answer. Her old number was 877-9609-321. Question, no. See, I have his phone records and you know he never called it. There was never, answer. You have the 772-713-9807? Question, 90, yeah, 9807. Answer. I don't know whose phone that he called and FaceTimed with. I talked to him on FaceTime.
So, assuming that I let this portion in, is this going to be a reoccurring theme? That what else are you going to ask her about?
In terms of that, as well as the initial part where she says she doesn't recall what he said verbatim. That would be the part where he's saying that someone just shot the car up and was trying to shoot them. So I asked him if he was okay, where he was, and he's like, there's a car coming behind him, like hiding. He was like, there's some, yeah, he's like, yeah, there's some. I think they're still out here or something. So I'm like, are you okay? He's like, I'm okay. I said, well, where are Sack and Juvie? And he said, I don't know if they're in the car. I think they're dead.
And that's the portion that you're looking to have admitted?
So far, based on her current state of her testimony up to this point.
Is there anything else?
If there's anything else that she doesn't remember on that, for example, the Frito Bang or Frederick Gibbons is his actual name, aspects of that, anything about the condo in Miami, about the blood on the clothes. There's another part later on where she then describes the conversation again that he said. He just basically said that his friend they just got killed, and that he was like, there was lights coming, somebody's coming, someone's coming. I'm like, are they still out there, you know? Question, answer. It's like I don't know. And I said, we're on our way. Just so you know, stay put. We'll come get you.
Hey, shout out to everybody in the chat, man. Appreciate y'all pulling up, man. Welcome back to the channel, man. Day 4, Ynw Melly trial, man. I appreciate everybody. If you did smash the like already, you already know it's all love. Snow ain't no gang. You did!
So at this time, I'm thinking he's somewhere hiding in the bushes somewhere from whoever shot him.
And the statement goes on, there's other things that you're trying to get out through this witness that you're concerned that she may or may not remember.
Those are the relevant portions, Your Honor. There's a lot of other things that she indicates in the statement that I would agree would not be relevant, and that wouldn't prove an essential fact that is at issue in this case. So I would not be seeking to insert the entire statement.
Basically the portions that you just elicited.
Yes,
Correct.
sir. And I can I have the ability to, in a Word document, to isolate those so that they can be succinctly read, provided to defense as well, so they would have copies. But the case was...
We got one. Hey, one of my so elegant, so effortlessly Moderators, get this motherfucker Mario Morgan out the motherfucking chat, nigga. You don't come in here and tell nobody to do shit, bitch. You go fuck off and watch this shit by yourself. We in this bitch kicking it. This is a community setting, you dumb hoe. So next time you can come back. Somebody get that nigga mind right, nigga. Slide to the left.
Clear, and the statute is clear, the state cannot introduce that statement, but the defense would be able to if they so chose.
Thank you. And your objection is?
Your Honor, we have a copy of her deposition, which makes clear.
Can I stop you for a second?
I'm sorry.
What is counsel reading from now? What are you reading from now?
I am reading from her statement of December 12th of 2018.
You're reading from a statement, not a deposition.
Correct.
Thank you. I'm sorry. Go ahead.
Thank you. And before I go any further, Your Honor, I meant no disrespect. And I appreciate your and understand your authority, and you're making decisions. Whatever reaction I had was not intended to convey disrespect, whether I agree with your decisions or not. Her deposition of December 14th, 2022 will clarify the issue of whether this is a failure of recollection that the state is trying to refresh, or whether or not this witness has recanted her statement and is making an entirely different statement about the facts of that night. In this deposition, she is not claiming not to recall. She said she wasn't certain about the time of the call, but she quickly got herself together and came down here, and it took about 3 to 4 hours, like she said, and she got here around 12 or 1 o'clock, which would place that call at 8 or 9 o'clock in the morning. There are several other substantive statements that indicate that she is recanting that statement she gave on that day. She says the reason that she gave the statement was because her daughter was threatened with arrest, like she said here. She said that she feels threatened, and the first thing she said there, she's not talking about Jamel, she's talking about the state. She's on an ankle bracelet. They arrested her in the Virgin Islands and brought her over here. And the statements she is making in her deposition do not support and are I wouldn't say they contradict, but they're not the statements that are made in the statement that the state seeks to elicit. If the rules allowed her to put a witness on just to get in a prior statement, then they'd be in okay territory. The rules don't permit that. She's creating this pretext. Oh, you forgot that? Well, let me read it into the record. I would offer the court a copy of this deposition over lunch to review that makes it clear that she is recanting. She is not forgetting. She is recanting. And that's exactly what these cases speak to, and the process that the state is, what they're attempting to engage in is to violate and circumvent the rule and admit out-of-court statements for the truth of the matter asserted, which are hearsay, which are recognized to create constitutional problems, which have resulted in some of these cases in murder cases being reversed, murder convictions being reversed, and she's inviting error into this court, into this trial, and we'd ask the court to at least get a context of what is going on here, whether this is a failure of recollection, whether that's the way she's fashioning it, or whether or not what she said in her deposition does not comport with what she said in that statement that she's recanting, and whether the state is just using this rule as a pretext to get the statements that they're not committed to.
Thank you. You have the statement of Ms. Holmes as well?
I do, Your
And that
Honor.
was taken under oath?
It was, yes, it's a sworn statement from Ms. Holmes in December of 2018. And Your Honor, I would also add that some of the time frame and issues of that, those were actually clarified because defense provided the state with reciprocal discovery of Ms. Jamie King's phone records, which authenticate the statements, for example, that Felicia Holmes said she immediately called Jamie King. That is shown in Ms. King's phone records.
Who's Jamie King?
the defendant's mother. So there's outside sources that corroborate the sum and substance of her December 2018 statement.
All right, so I'm going to take the statement. If there's no objection, I'll take the statement and the deposition. I'll read those over lunch, and then see everybody back here at 1:15. I told the jury to be back at 1:30. We'll resolve those issues, and we'll move forward. All right?
Thank you, Judge.
Thank you.
Relationship with someone named Jamel Denons, also known as Ynw Melly.
Yes, she did.
When was she involved in that romantic relationship with Melly?
I'm thinking maybe about 2016 or so till maybe 2019, 20.
Okay. Did you have the opportunity to meet Mr. Denons?
Yes, I did.
What did you refer to him as?
I call him Ynw Melly.
Do you see him here in the courtroom?
Yes, I do.
Where is he?
He's right here.
And what's he wearing?
A white turtleneck and a gray jacket.
Your Honor, the record reflected in-court identification of the defendant.
Yes, the record will reflect the in-court identification of the defendant.
So in October of 2018, had you met the defendant prior?
Yes, I did.
How many times had you met him in person prior to that?
A couple.
A couple?
Maybe two maybe.
Okay. Did you follow him on social media?
I'm not sure. In 2018, I wasn't. No.
Okay. Did you know if he had social media at that time?
I didn't. No, I didn't.
Okay. Did you have a social media account at that time?
Yes, I did.
And what was your social media handle?
I'm sorry.
What was your social media name?
My name? For which one?
For Instagram.
Instagram. It's like Bling Queen 258.
Okay. Did you have a Snapchat at that time?
I don't think so. If I did, I may have.
Okay. What about your daughter? Did she have an Instagram?
I'm pretty sure she did.
Okay. Did she have Snapchat?
I'm pretty sure she did.
Okay. So I'm going to show you what's been already admitted into evidence as State 61. There's a couple of videos and things on that I would like to ask you to ask some questions about.
Your Honor, we'd object as to the predicate being laid for this witness to testify to any of this material.
Thank you. Objection noted.
So I'm showing you what is titled Memories 2018 October 9th 4:58 UTC, Melly, Montana. Can you see that picture there on your screen?
Yes, I can.
Okay. Who is the female over there?
That's my daughter,
And which daughter is that?
Mariah.
Okay. Who else is in that photograph with her?
That's Chanel.
I want to go here to this image. This is 2018, November 11th, 23:53:26 UTC. Again, Melly, Montana. Who is pictured in this photograph?
My daughter, Mariah.
Do you recognize the individual in the back?
No.
Okay. Prior to coming into court yesterday, were you shown two photographs of the alleged victims in this case?
Yes, I was.
Were you able to identify them?
No, I was not.
In terms of your relationship with Anthony Williams and Chris Thomas, how many times have you met them?
Maybe Zach maybe twice. Judy maybe once.
And do you know them by their real names?
No, I don't.
How did you refer to them?
Scott and Julie.
Okay. So I want to go forward to some of the videos in this particular exhibit, specifically Memories 2018, October 18th, 2:17:49 UTC. Start with this one. I'm going
Before we
to...
tell me all that extra shit in like, they leave the most important shit here. Opinion.
So the image that is shown there, do you recognize the person in that driver's license?
It's blurry.
Okay. I'm going to show you another video, the next one
The most
here.
important shit here. Like, get right there. Like, you know you come back.
Whose driver's license is that?
That's my daughter.
The conversations and things that on there, do you recognize the voice?
I didn't really listen. I mean, you have to play it again.
Sure.
Before we tell me all that extra shit in like, they leave the most important shit here. Opinion.
Do you recognize the person who's speaking in that video?
Yes, I do.
Who is that?
That's Janelle.
Okay.
And so that was just a portion of the testimony from Felicia Holmes, the mother of the defendant's ex-girlfriend there. Sonny, I'm going to start with you here. Felicia Holmes mentioned at the beginning of her testimony that she felt threatened. How would you assess that, and what could a jury be reacting to hearing that?
I think when she said that, and as I heard her say that, I think she was scared about testifying, scared that she might suffer some repercussions from that. And the jury's probably wondering, why would she say those particular words? Why does she feel like her life might be in danger? And what is it that has happened prior to her saying that, or prior to this incident, that makes her feel so threatened? Either her presence, his presence, or what is really going on. So I think that's worth them unpacking later on.
And Bob, do you think Holmes comes off as a reluctant witness here?
In the beginning, she doesn't. She seems to be, very compliant, but there's obviously discomfort that she has in testifying here. So, and she's going to get walked through these tapes and what apparently are admissions relating to this crime that the defendant's charged with, and the gang overtones that are behind the scenes of this trial, whether they actually come in or enter the trial is another question. Those are things that I think the jury's going to look at, because demeanor, credibility, and what weight to give that are going to be very important in terms of what evidence they're going to accept and how heavily they're going to rely on it.
Yeah, I certainly felt she gave off some type of vibe that she was a little hesitant and holding back on how she really felt with the whole situation. All right, we're going to have to take a quick break here, but clearly a very busy day in court in the Melly trial. Keep in mind that we are going to have a Q&A session as well on this trial coming up around 12:30 p.m., so that's soon. So get your questions ready on social media. We'll be right back with more. You're watching Law and Crime. Welcome back. We are covering day 4 of the trial of Ynw Melly in South Florida. The rapper is accused of double murder for the 2018 shooting deaths of 2 of his friends, Anthony Williams and Christopher Thomas Jr. Let's head into that Broward County courtroom to hear more testimony now from Felicia Holmes.
So let's go back to October 26th of 2018. Where were you living?
I was living in Cocoa.
And my geography is terrible, I think. How far away is Cocoa from Broward County?
About 3-4 hours.
What do you do for a living?
I'm a registered nurse.
Were you a registered nurse at that time as well?
Yes, I was.
Did you know the defendant's mother?
Yes, I did.
And who is she?
Jamie.
Have you met her prior to October 26th of 2018?
Yes, I did.
Have you communicated with her?
Yes, I did.
Did you have a phone number for her?
I'm pretty sure I probably did.
I'm not asking you to.
I don't know if I did or not. I can't remember.
Okay. So I want to go forward on October 26th of 2018 and talk about that early morning hours. Did you receive or hear a phone call or a FaceTime video call in which the defendant was a participant?
I did overhear. I'm not quite sure exactly the context of the call, but I did overhear the phone call.
Okay. Tell the ladies and gentlemen of the jury what woke you up that morning.
Just hearing my daughter's voice.
Okay. What was the tone of her voice without saying what she said?
I don't remember. I don't remember.
Okay. Do you remember anything the defendant said on that video?
Not verbatim, no, I don't.
Okay. Did you have an opportunity to read the statement you gave in 2018?
I read the statement.
Okay.
I don't recall. I don't remember anything from that statement, but I do remember my deposition from December 22.
So the deposition, that would have been 6 months ago?
Yes.
Okay. I want to go, and when you spoke, you remember speaking with law enforcement in December of 2018?
I remember speaking with them, but I don't remember what they look like. I don't remember their names, but I do remember talking to someone.
Okay. So, Ms. Holmes, I want to ask you, were you honest and truthful with law enforcement when you spoke with them?
I would hope so. I mean, it was 2018. I went through a lot during that year, so I'm not sure where my mindset was at that time.
Did you lie to law enforcement?
I would hope not. But I don't remember what I said back. It was like 5 years ago.
Oh, of course. I understand it's been a long time. So, in terms of the time frame, that was closer in time to the incident of October 26th of 2018?
If that's where you guys are saying it is.
You don't even remember?
I don't remember. Because 2018 was a very hard year for me. My husband just went to prison. My father died. I had a lot going on, so I was really out of it.
Okay. And in terms of your conversations with the police officers that morning?
Yes. I do remember that they kind of bullied me and threatened my daughter to take her to jail for accessory after the fact. I do remember that.
Yes. And in terms of the statements that you made about what happened, you don't have any recollection of that? Did you read this statement multiple times?
I looked at it and I just didn't recall it, and I don't know.
And so you indicated you hoped you were truthful with law enforcement?
Yes, I did.
I have to ask you to be more definitive. Were you truthful?
I don't remember what I said to them back then, so if I was to tell you something now, I could be lying. I don't want to lie on the stand because you're going to take me to jail. So I'm saying what you want me to say.
I do not want you to say anything. I want you to tell the truth.
Okay, that's what I'm doing.
Okay. So, Ms. Holmes, with regards to that day, did you lie to law enforcement?
Objection asked and answered. Excuse me. Overruled. Repeat your question.
I don't remember.
Excuse me.
Yes, sir.
Only one person can talk at a time, and there was an objection. I just wanted to be clear. All right? You asked your question again.
Okay. So, Ms. Holmes, did you lie to law enforcement?
Not that I recall.
Okay.
I don't remember.
Okay. Going forward to the events of that day.
Yes.
When you heard that phone call, where were you?
I'm home.
Okay. Where was it? Home in Cocoa?
Cocoa.
Who else was there at your house?
My kids.
When you heard the phone call, did you hear what had allegedly happened?
I heard that there might have been a shooting.
Okay. Did you see any pictures or videos of anyone that was injured at that point?
No, I did not.
Did you see the defendant on the screen of that video call?
I saw his face, yes.
In terms of the method of communication, do you know if it was a FaceTime call?
I assumed it was FaceTime. I couldn't say for sure what kind of call it was.
At the time of October of 2018 through December of 2018, did you know the defendant's phone number?
No, I don't.
Do you recall today what the defendant's phone number was?
No, I don't.
Okay. In terms of the information and stuff that you have regarding that phone number, was that saved in your phone at that time?
It may have been. I can't remember.
Do you remember what phone number you had?
No, I don't. No, I don't.
So, Ms. Holmes, to go back in terms of looking at your statement or any of the other things, refresh your recollection as to what the defendant's phone number was and what you had at that time.
I'm sorry, could you repeat the question?
Sure. You said you didn't remember the defendant's phone number.
No, I don't.
Would looking at a copy of your statement help refresh your memory as to what?
No, I don't think it would.
Okay. Would you like to try to do so?
You have to look at it for you, sure.
Okay. And so, counsel, on for the record, I'm showing her page 3 of 8. And I'm going to ask you, Ms. Holmes, to just read this part silently to yourself. Okay. And we're going to start here, this, and through here, okay? Silently to yourself. When reviewing that, does that refresh your recollection?
No, it doesn't.
Your Honor, pursuant to 90.8035, the state would move at this time to read into the record the relevant portions.
Objection, Your Honor.
And so once again, that's a snippet of testimony from Felicia Holmes, the mother of the defendant's ex-girlfriend there. And Sonny, I'm going to start with you this time. I asked you in the last block if you find the witness to be reluctant. Now, as we get more into her testimony, do you think she's getting a bit testy and seems unwilling to testify for the state?
I absolutely do. Now that there's clarity, the threat is not coming from the defendant. She believes that her threat comes from law enforcement, the prosecution team, and she does not appear to want to cooperate with them in giving her testimony.
Bob, the witness seems to have trouble remembering details now. What do you make of that?
Well, the jury can look at it two ways. Number one, she's having trouble remembering details, and those are reasonable things to kind of forget over time. Or she's just trying not to be helpful with the, the questioner from the state, the prosecutor.
Sonny, how do you view that?
I view it that she said she had some personal things that happened. Her husband went to jail. That's reasonable, that a lot was going on. She might not remember. I also believe that she is a reluctant witness for the state in this particular case. Maybe not because she doesn't, based on her belief of the defendant, but because of her interaction with this prosecution.
And Melly's looking at her as this is all going on as well, so that could have something to do with it. All right, we have to take a quick break, but stay with us on Law and Crime Network. After the break, we are going to take your live questions on the air with the Ynw Melly Q&A that we're going to have. We do want to thank Sonny Slaughter, though, for joining me today. We do hope to see you soon. Great analysis, as always, Sonny. You're watching Law and Crime, everyone. Michelle Ewan. Thank you so much for joining us for a special hour on Law and Crime Network for the Ynw Melly double murder trial Q&A. Our eyes are in Broward County, Florida for the trial of Jamel Devins, better known by his stage name as Ynw Melly. The South Florida rapper is charged with 2 counts of first-degree murder for the 2018 shooting deaths of Anthony Williams, also known as Ynw Sack Chaser, and Christopher Thomas Jr., also known as Ynw Juvie. The victims and the defendant were all a part of the Ynw Collective, along with co-defendant Cortland Henry, who will be tried in a separate case. Now, if Ynw Melly is convicted, the 24-year-old could be facing the death penalty. While court is on their lunch recess right now, we will be taking your questions live on the air, so please submit them on Twitter, Facebook, and YouTube, Instagram, and TikTok as well, and we will do our best to get many questions answered as possible. And now I'm joined by a very special legal panel. We have Law and Crime Network's Brian Buckmeyer, Law and Crime correspondent Bryson Paul, as well as support online hip-hop legal contributor Afi Patterson. Guys, thank you so much for joining me here. This trial is receiving such national attention for many reasons, and there's so many twists and turns and drama. It is day 4 of this trial now. Brian, what has stood out to you thus far?
What stood out to me, I think, is the same thing that stood out throughout the trial so far. I'm trying to figure out where the smoking gun is in this case. Maybe it was the trajectory information where they're saying, hey, Ynw Melly was sitting at this seat at this time. We saw a video from the recording studio of him entering the car. The shell casings and the trajectory of the bullet suggest that whoever's sitting here is the one that did it. But other than that, I'm not really seeing that damning evidence that the prosecution promised in their opening that should be playing out in this trial.
And Bryson, many people are talking about the demeanor of Melly after he was seen in the courtroom smiling and blowing a kiss, which the victim's family called disrespectful. How could a jury be reacting to that?
Oh, the jury is acting very mild, very not really paying attention to what is going on in the gallery, really just paying attention to the evidence at this time.
And Afi, how would you assess day 4 and what you have heard thus far?
So day 4 has gotten even.
Today has been. I think today's been fantastic. I think the defense has done a really great job, especially dealing with the Snapchat information, making their objections clear on the record, making sure that they bring in a first tier law to explain their objections and making sure that they make a beautiful record, I think, in the event of appeals. I think that part has been fantastic for me. I also think I agree with the other correspondent. How is the prosecution going to put the gun in Melly's hand? How are they going to make him the trigger man? I understand their theory. They have promised a lot, but I don't see how they're going to put the gun in the hand. That's what I'm waiting for. All right, great analysis as usual, guys. We're going to now take questions now from all of our viewers. Please keep them coming. We're going to take a question now from Creeps Cringe TV from YouTube asks, do you think that the prosecution has used the 4 years that they have had Melly incarcerated in the best way to build a case against them, or have failed to come up with more evidence to seek the death penalty? Brian, your thoughts?
I don't think so. And maybe it's stylistic, but this is the way I think about presenting any kind of argument to a jury. I want to be the first one to tell you something. I want to tell you more often than the other person, and I want to be the last one to tell you as well. And what I mean by that is, tell me why he's guilty early, tell me why he's guilty often, and give that last word as to why he's guilty. If a jury is waiting 3, 4, 5, how many ever days it gets to, till we get to the heart of the prosecution's case, you may lose people. You may have people drifting away. You might have people looking at Ynw Melly and be like, I would be laughing too at this point in the case, because there hasn't been that hard-hitting evidence that makes me think I'm on your side. You want to get the jury on your side as quickly as possible, and I'm giving the prosecution the benefit of the doubt. I'm sure they have something that's going to come. I'm saying do it now and grab and contain and hold the jury's attention for the rest of the trial. Otherwise, you may never get them.
All right, we have another question now. Bryson, I'm going to let you take this one. This is from Young Baller from YouTube. He asks, how are tensions in the courtroom on day 4?
Tensions are the same as day 3, and it's very, 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 very tense between both sides, both Melly's gallery and both the victim's gallery. The families of the deceased are very upset, very angered by Melly's approach, just his demeanor and while he sits in the courtroom, he smiles, laughs, talks to his mother and his special guests in the courtroom, and prays. And the family of the victims are still hurt that their significant others are lost, and just angered by the lack of remorse that he has for them.
All right, Afi, we have another question from YouTube from Renard Preston here. They asked, is it still possible for Cortland Henry to be used as a witness of the state, or would he have already needed to be identified as a witness by them prior to the trial beginning?
Because we know who he is. There's no surprise. He would have needed to be identified from the beginning. But also, if he takes the stand, it's easy for him to just invoke his Fifth Amendment right not to testify, not to incriminate himself. Can I also say about yesterday, you don't want to drown your jury in jargon. I think the gun expert drowned their jury, and there was a comment on it that you could have gotten a certificate in whatever he was discussing, but you don't want to lay it on heavy. You want to talk to me like I'm a 4th grader and just guide me through in pieces that I can understand. That's how you're going to keep me. That's how I'm going to not zone out, and I'm going to continue to be engaged.
Well, like I said earlier, there is so much for this jury to take in, let it all sink in. We're going to see where it goes later after their lunch break. But guys, keep your questions coming. We're going to take a quick break here on Law and Crime. We'll do our best to answer all your questions on the air. Stay with us. We'll be right back. Welcome back to a special hour on Law and Crime Network here for the Ynw Melly double murder trial Q&A. I'm Michelle Yu. Our eyes are in Broward County, Florida for the trial of Jamel Demons, better known by the stage name Ynw Melly. The South Florida rapper is charged with 2 counts of first-degree murder for the 2018 shooting deaths of Anthony Williams, also known as Ynw Sack Chaser, and Christopher Thomas Jr., also known as Ynw Juvie. For the next hour, we'll be taking your questions live on air, so please submit your questions on Twitter, Facebook, YouTube, Instagram.
Hey, shout out to everybody in the chat, man. Appreciate everybody rocking with the screen, man. Please, 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 all I'm gonna ask, man, just one thing only, man. Please smash that like. If you already smashed it, you already know it's Snow Gang and No Gang. If you want to stay tuned in, hit the subscribe, then hit that note of motherfucking-cation. Always remember, I'm in the back. I just took my video off so the shit can run smooth. It's been running pretty smooth. So shout out to everybody in the chat, man. Case getting crazy, nigga. Let's get back into it.
TikTok, and we'll do our best to get as many of those questions answered as possible. Before we get to those questions, though, I do want us to recap the testimony of forensic scientist Tara Helschel. She was a witness for the state, so let's listen to her testimony from earlier.
Did you ultimately have a chance to analyze and go through this SEM process, which is the automated process, and your individual process, in order to come up with an opinion as to the presence of GSR?
Yes.
And what was that opinion? And if you can specify both the left and then the right.
Mm-hmm. So the right hand of Cortland Henry contained 0 particles characteristic of gunshot residue and 2 component particles. And the left hand contained 1 particle characteristic of gunshot residue and 1 2-component particle.
Okay. And can you explain to us what that means?
Basically, overall, there was gunshot residue present on the hands.
Okay. And what affects the presence or absence of GSR on a person's hand or any object?
Sure. So if there is gunshot residue on someone's hands, that means that the individual got it on themselves by either discharging a firearm, being in the proximity of a firearm when it was discharged, or by coming into contact with a surface or object with gunshot residue on it.
Okay. And if we may go back to the demonstrative aid, what was this demonstrative aid? Was this representative of your results of Cortland Henry?
Yes, that was the particle characteristic of gunshot residue that was on the left hand.
And the components, which you explained before, there are three kinds or 3 compounds that you were looking for, and which compounds were present in Cortland Henry's left hand?
Lead, barium, and antimony were present in that particle.
So all 3 components?
Yes.
Okay, and let's move on to stage 60, which was the sample for the G. What were your results? And again, did you also go through the SEM automated process and then your individual characteristic process?
I did, yes. So there were 0 particles characteristic of gunshot residue, but at least 9 2-component particles.
Okay. And what does that mean?
So, like I mentioned, 2-component particles can come from gunshot residue, but they also have other sources. So, because of that, these results are basically inconclusive. They could be gunshot residue, but they also could be from something else, and I can't say which it is.
Okay. In your analysis and reviewing the sample, did you find anything inconsistent with gunshot residue, if I'm phrasing that correctly?
Correct, and I did not. So overall, with 2-component particles, or any of the particles we look at, oftentimes if the particles are from another source, there are other elements or amounts of elements that would be unusual to find in gunshot residue. So, for example, one common source of 2-component particles is brake pads. Brake pads typically contain high amounts of the element iron. So if I'm doing my analysis and I come across particles with high amounts of iron, I eliminate them and I do not report them because there's something about them that would suggest they're from something else. So while I still cannot call these particles gunshot residue, there was nothing about those particles that were unusual.
You got the sample from Miramar Police Department?
Yes.
specifically Detective Moretti directed to you. Correct?
Yes.
And when we talk about GSR, or gunshot residue, you're aware that GSR can be found on clothes, correct?
Yes, that's possible.
Did Detective Moretti send you any clothes of Cortland Henry?
He did not.
He didn't send you any of the clothes?
No.
Did you know that the clothes of Cortland Henry were collected by the Miramar Police Department?
Objection calls for speculation outside the scope of the court.
Well, I don't know that it calls for speculation. She knows she can answer the question. Overruled.
Were you aware that the Miramar Police Department collected Cortland Henry's clothes?
No, I was not aware of that.
So forensics is going to be key in this trial, and with that as the backdrop, I'm once again joined by a very special legal panel. We have Law and Crime Network's Brian Buckmeyer, Law and Crime correspondent Bryson Paul, as well as Support Online hip-hop legal contributor Afi Patterson. Brian, I'm going to start with you here. What stood out to you in this testimony dealing with the forensics?
That it was pointless. I mean, if I was a defense attorney, after I hear the words from the supposed GSR expert, I cannot tell you if this is GSR or something else. What was the word? All I could say is that it's common. So I would come up and say, Judge, what's the relevance? What did this testimony just do for the jury to tell them whether or not my client, Mr. Demons, did or did not commit a murder? Even go beyond that. If we're agreeing that this shooting happened inside of a car, and I would have got this out of the witness, GSR travels about 3 to 5 feet, and everyone is within 3 to 5 feet of each other. What's the relevance? They all got GSR on them. But you can't even tell me that. So I would have struck in the entire witness's testimony. I would have turned to the jury and said, sorry, the prosecution wasted your time. I'll try to make up for it down the road.
Afi, did you find this pointless?
You know, I did. And the thing is, GSR is so easily transferable. And it doesn't tell you the source of it, doesn't tell you the origin, just that it was present. And given the situation, anyone could have gotten GSR transferred onto them. So it was pointless. But not only that, the prosecution has brought up a number of witnesses. And if you'll notice, the defense only asks probably 1 to 3, maybe 4 follow-up questions and to me, that shows that this witness is basically pointless. You are just doing a demonstration. So I definitely agree. I don't understand the point except to just establish that GSR was present.
All right, we're going to take some viewer questions right now. Brian, you're up here. Jimmy Rowland from YouTube asks, where are the exit bullet holes that leave the car that are seen in the back seat? Do they exit the vehicle through the front or back to indicate the direction? Was the car searched for gunshot residue inside the car?
So typically when they search for gunshot residue, it's typically on a person's hands or their extremities because they're trying to see whether or not the person handled the gun. I'm not sure, and I don't think I've heard whether or not they tested GSR for the surrounding areas of inside the car. I think that'd be redundant because they've already got the bullet holes. In terms of the trajectory, it's hard to tell just from trajectory alone as to where the bullets came from. But because they're charging Ynw Melly with the shooting and not the co-defendant Henry, I believe they're saying the shots come from back to front. And I think if you follow the strings that they're kind of pointing there, you see on the screen, you can somewhat see the trajectory. Where they landed, I think they maybe went through the hood of the car, maybe some fell in or some were still within the decedent's bodies.
All right, Bryson, you're up here. Melly Innocent from YouTube asks, is Bortland getting arrested soon, or is he free until Melly's trial ends?
Currently, he's on house arrest, and he's free, and he's been free since 2019.
And Bryson, we have another question now from YouTube. Liz Herrera asks, do you know if Melly and his ex-girlfriend's mom are on good terms?
I wouldn't say that Melly and the ex-girlfriend's mom are in good terms, but we definitely just saw his younger brother and the mother of his ex-girlfriend walk out the courtroom and hug and embrace each other.
All right, and Afi, there's a question for you here. Letitia from YouTube asks, does the state's evidence and witnesses connect the defendant to the case so far?
Yes. he's definitely connected to the case. I think the video beginning with him leaving the studio, was it at 4:02 a.m. or something around that time? So that's definitely the start of the connection. And then you have to look at the drive that he took. We do know that the red car went into the community where they were all living or staying while they were reporting. And then Cortland went on to the hospital. So, and then he's, of course, also been connected with the mother's testimony. And I believe she said, or is expected to go into detail, where he calls her daughter and says that he believes that, Juvie and Sack have been shot, and it was a drive-by. So he's definitely connected. He's in there. Without a doubt. I think that they just need to, for me, I have not seen them put the gun in his hand.
All right, we have under
I need to see.
a minute here, Afi. I just want to ask you 20 seconds, another question from YouTube. What happens if there's a hung jury?
If there's a hung jury, the prosecutors are going to have to regroup, and they will have an opportunity to decide whether or not they want to retry the case.
All right. Well, thank you for answering those questions. Great insight, great analysis, as always. We're going to take another quick break here on Law and Crime. But when we come back, we are going to take more of your questions, and we're going to dissect more of this case involving Ynw Melly and his double murder trial. It is day 4 of this case. They are currently on a lunch break right now in Florida. More to come here on Law and Crime. We will be right back. Hi everyone, I'm Michelle Yu and you're watching our special Ynw Melly double murder trial Q&A session here on Law and Crime. In case you're just joining us, our focus is on Broward County, Florida for the trial of Jamel Demons, also known as Ynw Melly. The South Florida rapper is charged with 2 counts of first-degree murder for the 2018 shooting deaths of Anthony Williams, also known as Ynw Sack Chaser, and Christopher Thomas Jr., also known as Ynw Juvie. We are currently taking your questions on air, so please submit your questions on Twitter, Facebook, YouTube, Instagram, TikTok, you know it. We'll do our best to get as many questions answered as possible. Our legal panel continues to be here with us to break everything down. So Brian Buckmeyer, I'm going to ask you here, YKX2 from YouTube has a question. Question is, why is Melly getting the death penalty and Bortland is getting life in this?
Great question. I have to look at this into this myself. The main reason I think is because they think he's a shooter. I think they looked at the trajectory of the bullets. They look at the video from the recording studio of when people went in to the vehicle, and they say, hey, bullets come from here. Ynw must have sat here. Therefore, this is the shooter. They should get the death penalty, as opposed to Henry, who goes up and lies to the police, according to the forensics and the police, to say there was a drive-by. They're saying he's not the shooter, Ynw Melly is the shooter, and that's the difference there. That's about all I got. I think they could have, and also Henry's charged with accessory after the fact. They could have gone the death penalty for both, but I think those are the facts that lead to their decision.
Great clarification there. All right, thank you, Brian. Bryson, this one is for you. Question from YouTube here. Amanda Johnson asks, why did the defense suggest Melly cover up his tattoo of the victim's mother's name, according to Juvie's father?
They believe that it would be a perception for the jury, and they didn't want to have any. They wanted to leave things at unbelievable, or they wanted to leave things that are just that could cause any type of sway in the jury to go to being guilty or versus being not guilty, and they just didn't want any perceptions, they didn't want any cracks, anything. So.
Yeah, the turtleneck and the tattoo has been a big topic of conversation. A lot of viewers wondering why.
That has testified that the witness doesn't recall, and you're suggesting that I take it that she's feigning a lack of memory?
On some of them, I think it's accurate that she doesn't have a verbatim recollection of what was said. I think if she said that she did, that would be suspect. I think so. In terms of having a better memory back in 2018, 2 months after the incident or less than that, that is valid, and that she had said she was truthful with law enforcement at that time. So the state has met the admissibility threshold on that particular issue.
Thank you. And what says the defense?
Your Honor, I think the state undercuts its argument by admitting what she perceives to be the case, which is that concerning the gravamen of what she's trying to introduce, she believes that the witness is feigning a lack of recollection. In other words, she is recanting. So this is not, and what's important to realize is this is not about determining whether we have a witness who is being honest or not. I think this rule contemplates a witness who...
Okay, so they have went live on another stream. God damn it, they switched over the lives on us. Let me see, hold on. Shout out to everybody in the chat, man. Please hit that like button if you in the chat right now, man. You know I'm gonna make sure we stay on point with this shit, you heard? What the fuck? No crime. Let me see. Damn, gang. Alright, here we go, right here. They switched it out on us. I guess the Parkland shooter, whatever the fuck that is. Yeah, they switched it out on this game. Let me see. Let me press pause. Shout out to everybody in the chat, man. Please smash that like button. We back, man. They switched over the lives and shit. God damn it. Hold on, my fault, y'all. My fault. I'm gonna fix it. Smash that like. Y'all on that DA, bro. She probably gonna be reading these comments and shit like that. Y'all blowing her head up. She's so thick. Damn, what about the sister? Y'all, that's too much booty for y'all? That's too much ass? Too bootylicious? No, I'm fucking with y'all, man. Hey, listen, I ain't mad, man. I love women, so don't get. Hey, I understand you. I overstand. Just want to make sure it ain't lagging or nothing like that, gang. Alright, let's get it. Shout out to everybody in the chat, man. Please hit the like button if you haven't. If you have, I appreciate you. Welcome back. Day 4 Ynw Melly. Shit's getting intense, man. I think this was the most intense day so far. I ain't gonna lie.
Citations. I provided a copy to defense and a copy for your honor. And the light is located at 116 7th 3rd, 270 Florida Supreme Court, 2013. What the fuck is going on, y'all? Shit kind of laggy a little bit, right? Let me see. I think I fixed it.
Sorry for the lag, y'all. It's trying to catch up. The screen is trying to catch up. I don't know if it's a little delay on it right now, but it's trying to catch up. I'm still here, y'all. Smash the like. It should be picking. It should be getting on, clipping on in a minute. Let's go. All right, let's try this again. Put this bitch on 144, goddamn it. Let me try to put it on the lower quality. Shit getting. Sorry about the lag, y'all. I'm trying to fix it, y'all. Y'all seen it was going, we was doing good. As soon as they switch over to goddamn live, they fucking us up. They trying to put us in the twist. You heard me? Trying to put a nigga in the twist, man. Let's try this one. fuck, bro? I'm trying to figure out what's going on here, gang. Can somebody be of assistance? Why do this? Damn, bro. This shit laggy. What the fuck, gang? See, I told y'all I ain't even do shit. I really didn't. I ain't even cut my camera back on. These niggas still trying to lag me down, man. Shout out to the gang, though, man. You said, what do I have running? The shit just started lagging like a motherfucker, man. I ain't gonna lie. Let me see. Let me try and work it like that. I don't got shit, bro. What the fuck? Oh, dang, I don't know, bro. It just started switching up. I literally didn't do nothing.